Right.
Morning, Ed. Can you hear us okay?
Yeah.
Okay, great. We're gonna mute again until we get started, just so we don't get.
Okay.
Morning.
Hey, hi Julie. How's your foot?
Well, I'm looking and I see Barbara's in a boot too. And my husband just said, well, she can make it.
So how is yours? Coming along?
Well, I hope
No?
so.
You hope so, huh?
I hope so. Okay, I think I'm set.
Well, I hope I wasn't too sarcastic in my response.
Oh, no, and I meant to write you back. Not at all. I need a pillow to get up, I think.
That's what I say to my kids all the time when they complain, and I say, run it off.
Yeah.
different speaker and then switch back.
Barbara. Can you hear me? No.
Good morning, everyone. Oh,
Sorry,
thank
everyone.
you.
We're having some difficulty with our audio. We will be with you shortly.
Yeah. You.
Okay, try now.
All right, can you hear us?
Yeah.
Okay, great. The computer we were using died. I don't know what's going on. It's a Monday. So we were working on coming back online.
You can hear you, but not seeing the video.
Yeah, we're still connecting to the camera.
Got it? There you go.
Okay.
Okay.
Great. So Ed, I think we can get started.
Okay. So
We
it's
can't turn the volume up on that.
it's 8:32 on behalf of my fellow commissioners and myself. My name is Ed David. I will call the meeting to order. There are published agendas. The first item is to consider the agenda itself and the consent agenda. Are there any amendments to the agenda? Kat?
They're not.
If there are not, then a motion would be in order to accept the published agenda, consent agenda.
Moved.
Second.
Jane, can you turn that volume up, please?
It's 100% on the TV, so I'm gonna try to turn it on my computer.
All right, moved and seconded. Any discussion? Okay, seeing none, the motion, the motion is not to find any kind of grounds. Is to adopt the agenda, and the commission's remote participation policy requires that the commissioners indicate their votes both visually and audibly. So if you're in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Okay. So next would be to adopt the June 2026 minutes.
I've reviewed them and I don't have any amendments. I will move to adopt them unless there are corrections or additions.
Second.
Any discussion? Seeing none, if you're in agreement, you will vote yes. Commissioner David,
Yes.
Commissioner O'Brien,
Yes,
Commissioner Douglas. Jane, can you pin Ed?
I don't know. Yeah. Yeah. Not gonna let me.
You are.
It only says replace pin. Hold on.
All right. So for directors' reports, I have updates for you. We have hired a new Secretary of Associate Legal to move into Jillian's position since she became the business manager. She will start tomorrow. Very exciting. And we have hired a new investigator starting on August 10th, which leaves us with only one vacant investigator position. We're going to be almost fully staffed for the first time in I don't know how many years, but it's very exciting. So that is big news for us. I think actually that it has changed since I wrote the personnel memo, which was that we had made offers to two people. They have since both accepted and we're actually going to start. We're very excited. They're both excellent, and you'll meet the investigator, and I hope also the new Secretary of Associate Legal once she sort of gets her feet under her. But we'll bring them all up for at least one commission meeting so they can see the chaos. For compliance, we have a memo from Jane. We have 1 unsuccessful conciliation and 6 inactive conciliation. So Jane's going to be busy. For new charges, we had 48 complaints with a total of 87 respondents in the last month. 13 closures before they got to the end of the process. So 13 administrative dismissals, 6 right to sue letters, 11 withdrawals with benefits, and 2 withdrawals without benefits. For the withdrawals with benefits, 4 of those settled privately, 6 through the commission's mediation program, and 1 settled while it was in investigation, for a total of about 345,002 complainants. This is the quarterly meeting, so for your quarterly updates, for pending inventory, we have 604 open cases currently, with an average case age of 297 days, which is still pretty good for us. That's an average of under a year with the commission. 191 are in processing, which means that they have not been in, we have the initial pleadings, the complaint, the answer, the reply, but they haven't been invited to mediation or anything like that. They're still in that process of waiting for those pleadings to come in. So 191 in processing with an average case age of 78 days, and 155 in active investigation with an average of 214 days since an investigator has been assigned them. Pretty standard for us. Pretty slow quarter in terms of training and outreach, only 7 events last quarter. But given the fact that we're pretty understaffed, that we've just been focusing on getting the commission's work done. And for finance, you have a report from Michael, and if you have questions about it, I will direct you to Mike. Great.
I always want Michael to give us a little interpretation.
Yeah.
I'm a little confused by the total expenses and the income. I mean, it says the total expenditures are 2 million and the income is 1,619,000.
Oh, the 1.6 is for the state funds only.
Okay. And the total expenditures reflects the spending the federal money, right?
The total expenditures at the very end respect all of the funding, so is total of all of the funding sources. So each column represents a different funding source, and they're labeled at the top of the bar.
And how is our funding coming with the feds? Maybe that's a question for Kit.
We actually did receive a payment from the EEOC recently. It wasn't as much as we would like it to have been, but we still did receive some money from them a couple weeks ago.
It was what we were expecting to get. There's a process with the EEOC contract where you can voucher for 20% of the cases before you had like sort of during the fiscal year. So we did that in February, and we got the fund like a week and a half ago. I don't know what the holdup there was. I got some information from my EEOC contact, but none of it made much sense to me. It seemed like, I suspect the problem is that they are understaffed. And there weren't enough people paying attention to get it processed on their end, because once I bugged them about it repeatedly over the course of several months, we did eventually get the money. It is the end of our HUD fiscal year. We are wrapping that up. Allegedly, we will be paid for the work that we have done this year. I'll keep you posted. The EEOC fiscal year doesn't end until the end of September. We're on track to meet the number that I think we're contracted to close. They haven't actually told me what that number is, but I have extrapolated it from the amount that we got the voucher for in February. So we're on track to meet that number, and hopefully we will get paid for that as well. But I will we'll take litigation in executive session. This sort of brings me to new business. So we're getting ready again to do the budget, my favorite time of year. It's the biennial budget this year, so this is the big one, and I am putting in an initiative to move one of our federally funded investigator positions in the general fund, just because it seems prudent at this point to move as many of our positions into the general fund as we can. We're fine on federal funding for a few years, particularly since we got 4 positions moved into the general fund in the last budget. But it's a shifting wind, shall we say.
Did we receive the budget request that we made last year for the supplemental?
We did.
Okay,
And that will go into effect in 2 days. I believe the effective date for this past session is July 29th.
okay.
That is all I have. Will we be in recess for a few minutes, and that will hopefully give us a chance to sort out some of the technical issues that we're having.
Sure. We'll start with the hearing agenda at 8:45. And we'll be in recess until then.
Barbara?
She can. Julie?
Did you say my name?
Yes, I see that you are basically in the same position as I am, and Mark just said, well, she could make it.
Well,
Oh, yeah.
my boot is optional for the next week or so. I'm waiting for Achilles tendon surgery to get started.
Oh, okay, okay. It's still not fun.
It's not fun, and I'm not gonna be able to bear weight for a while. So next week I might be unable to attend. You can tell Mark.
Yeah, I can spotlight when people's video. Okay.
Okay, we'll call the meeting to order, Kit, is that all right?
Yep.
Okay,
1 minute, we need to spotlight the interpreters. Okay. Great.
so we'll proceed to the hearing agenda. Good morning to the folks that are here for the hearing agenda. My name is Ed David. On behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I am asking each of you to who may have an electronic device, cell phone, pager, etc., to ensure that they are silenced now. We have additional agendas, including the consent agenda available online and in the hearing room. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted time. The commission has voted on those will vote on those cases, and they will not be considered further today. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium or recognized online to provide the most relevant arguments to the case. The time for the presentation is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only one relevant factual errors, relevant omissions from the report of facts submitted during the investigation, relevant issues and questions concerning interpretation of law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions. I will ask that you introduce yourself as you come to the podium or are recognized. The first case for hearing is public accommodations case PA 240174, Satara Sheik, if I've said that correctly, versus Portland Gastroenterological Center. The recommendation from the investigator is that we find that there are reasonable grounds on the one count, and therefore we will hear the presentation first from the respondent. And the director has general instructions. Go ahead, Kit. Yeah.
Before we get started, the Maine Human Rights Act has confidentiality provisions that make confidential anyone who is not named as a party to the complaint. Those people or entities have been given pseudonyms in the report, so we'd ask that you use those names. Please do not use the names of the people or the entities. You can use a pseudonym that has been given in the report, or you can use their title or relationship to the parties. But please do not use their names. And since this first case is being ASL interpreted, we're going to give the parties 15 minutes instead of 10 to present, and ask that everybody remember to please speak slowly and clearly so the interpreters can catch what you are saying. I believe I'm looking for Attorney Remmel. Yes, okay. Do you want to reserve any of that 15 minutes to respond?
Yeah.
A minute? Okay. Right, whenever you're ready.
So my name is Charles Remmel. I'm Remmel, and I represent Portland Gastroenterology.
Hang on one second.
Sorry, this is the interpreter. I'm unable to hear clearly what the attorney is saying. Is it possible to move closer to the microphone or speak a little bit louder?
I'll try to speak more loudly. Not sure what I can do about the microphone here. In this particular case, and I just generally want to start with by saying when medical care can be accessed in Maine, it is a way of high quality and provided with professionalism, strong patient support. Many of us in our room have experienced that ourselves, and for our families and loved ones when they are engaged with the medical community. The record in this case is that Ms. C also agrees that with respect to the medical treatment and medical care that she was provided, that she acknowledges that that was done professionally and it was done with respect. And I'll quote from what I call the joint meeting where the parties were present with the investigator, and it was recorded. And this was her quote when she was asked about the treatment that she received and her treatment by the professionals at Portland Gastro. In quote, "Everyone was professional. They were great. They were very professional." And that occurs at 1 hour, 12 minutes and 54 seconds in that meeting. So the question that you're being asked to consider is not whether she failed to receive proper care on a professional basis or lack of respect. She concedes that that part is fine. What the claim is that she should be entitled to a member of a class of this disabled deaf community, and to a member of that class that she should be entitled on demand to receive an in-person ASL interpreter, and that BRI is not an acceptable alternative. And in that entitlement, she's claiming that she's entitled to an ASL interpreter in person, regardless of whatever other accommodation might be provided to her to make sure that there is effective communication. Now, there's a couple of points here that I think are very important. One is that no record was made or attempted to be made by Ms. Seek that she had any special medical, physical, or other condition that would make the use of BRI unsuitable. Why is that important? Well, the reason it's important is because of the following. The parties agree, I think there's a fair statement that they agree that Maine and federal law are in accord with respect to the requirements to provide accommodation with people with disabilities. In the case of the federal government, the Department of Justice and Civil Rights Division has issued a guidance letter, an interpretive letter, if you will, that talks about what is an adequate or what is an accommodation that's appropriate to be used and what is acceptable for purposes of meeting that accommodation. And I'm just going to read a short part of it because it's very important to get this distinction, because there was no record made that Ms. Seek falls in some special category. And I'll quote from page 5 of that guidance letter. says this guidance letter was written at the time when the regulations were first being promoted. The new regulations give covered entities the choice of using VRI or on-site interpreters in situations where either would be effective. VRI can be especially useful in rural areas where on-site interpreters may be difficult to obtain. Additionally, there may be some cost advantages in using VRI in certain circumstances. But here's what's important. However, VRI will not be effective in all circumstances. For example, it will not be effective if the person who needs the interpreter has difficulty seeing the screen, either because of a vision loss or because he or she cannot be properly positioned to see the screen because of an injury or other condition. So Ms. Seek has not put herself within this exception. She hasn't made any record about that, and she didn't attempt to make any record. She does have a protected disability. That's not a dispute, or a covered entity. That's not a dispute. So the point about this, I think, is obvious, is that they're saying you can use VRI as an alternative. It's in this guidance letter that that's an appropriate outcome, unless the person happens to be in some special category with some special physical disability or otherwise. And in that instance, it might not be appropriate, and you might have to use an in-person. But that's not this case. So I'm not going to go through all the positions we put in our written submission, which I will just call our objection letter for want of a better term. But there are some points that I would like to make. One of them is that one of the things we do for people with disabilities and people who have who have language problems is we provide what's called a preoperative meeting. And what that is that we basically have bring the person in and who can personally meet with a nurse or a nurse practitioner to go over what the procedure is going to be and to answer any questions that the person might have. That's not done for a regular patient who has no other issues. They just get a mailing with their instructions and so on. So in this particular instance, we did have that meeting. Now, one of the complaints that Ms. Seek has is she said, well, fine, you gave me this meeting, but you were using VRI, and sometimes the internet transmission would hesitate, and to use her terminology, it would freeze. And in her unsworn written submission, she goes over that and says that, this caused her problems. But when she was asked by the investigator in the joint investigative meeting about this, she was asked twice, what effect did that freezing have on effective communication? And she said, well, it only required me to get additional clarification at the time. And she was asked about it twice because it was an important point about what she was trying to make, that, oh, this interruption was very significant and I was losing information. Yet when she was asked about it, she said, it only required me to get clarification. And she said that at minute 56 and 30 seconds, and she said it again at 1 hour, 2 minutes and 40 seconds. So because the investigator is going back, could you see the person's hands? Could you see their fingers? Could you see the screen? Could you see this? Well, if you're talking about hesitation that occurred in the internet transmission, what effect did that have? Well, it just required me to get some more clarification at the time. Now, one of the problems here is that we didn't just simply say, oh, we provided VRI and we're all done. We provided an explanation, and it's in our written submission, as to the reasons why there's poor patient outcomes when you're trying to meet an on-demand, in-person ASL requirement. And Portland Gastro is no different than the other medical, most of the, I'd say virtually all medical professions, medical practices in Maine, they do it through BRI. And there's a lot of reasons for that. But we went through it, explained why we did it, why it gives poor patient outcomes. And one of the things that I wanted to tell you is you know, for Portland Gastro, their procedure rooms are scheduled out 30 to 90 days, 60 to 90 days in order for you to, if you miss your appointment or something happens with the ASL interpreter or you run off the allotted time that you have for them, the result is that you get bumped now 60 or 90 days out. And I just want to talk about that in terms of this proceeding, this case, as a microcosm of what the problem would be and why trying to schedule ASL interpreters can lead to a lot of problems for the patients. In this case, meaning this proceeding, we were supposed to have this hearing in May. And in May, it had to be continued. And this is Kit sent the parties an email saying, in quote, "Good afternoon. Unfortunately, the agency we use to schedule ASL interpreters just got back to us that they are unable to schedule interpreters for Monday's meeting. I apologize for the late notice. We tried several times to get confirmation before we heard back." That is a microcosm of the problem. We're using ASL, BRI interpretation for ASL people 40 times a year. We're using it for people who have language difficulties 600 times a year. We're pretty familiar with the system and we think it's effective. Now, in this, we've said throughout the record, and we've said it again in this appeal, that this is really a test case. Ms. Seek is the co-president of the Maine Association for the Deaf, and that association and the National Association advocate for a policy position that there should be broader availability of in-person ASL interpreters. That position, whatever its merits, and it does have merit, would require a number of policy issues that we don't need to get into here about training more ASL interpreters and maybe changing the certification requirements to do it and funding and all these other sorts of things. But that's not where we are. What we have is a legal criteria right now that BRI is deemed to be an effective form of providing ASL interpretation. That's what we've done, and I've read from the regulations, and you have those, and from the interpretive letter that makes that fairly clear. One of the things with a test case, though, is if you were to, the commission were to put its weight behind this policy preference of the Maine Association for the Deaf, then this is going to affect medical practices across the state, because everyone, virtually everyone, provides this accommodation via BRI. And you know, we also have a rural state. We've got a lot of, it could be a really big change for the industry. I just want to close with it because there's a certain irony here. We're arguing about whether BRI is an effective form of communication using translators on screen in this case. And here we are in a proceeding using BRI or screens, because Zoom is functionally the same as BRI, using it in this proceeding. We shouldn't be arguing about whether that's effective or not. I mean, apparently it is, because we're doing it here and it's done across the state. So the argument sort of reduces itself to the seat made a demand. We didn't meet it. We met it, and we provided an accommodation. We think it was an appropriate response, and that's I think we're urging the commission not to accept the proposed finding of discrimination. So thank you for your time and consideration.
We'll stay here and see if the commissioners have any questions. Commissioner, questions for Attorney Remmel? All right, we'll have 1 minute left when we come back to you. Attorney Decker, you have 15 minutes. Do you want to reserve any of your time?
Yes, please. I will reserve whatever time I have remaining. Thank you so much.
Whenever you're ready, go ahead.
Great, thank you. Good morning. My name is Tess Decker, and I am representing the complainant, Ms. Sitara Sheikh. The issue in this case is simple and straightforward, and it is that PGC unlawfully discriminated against Ms. Sheikh when it effectively denied her request for a reasonable accommodation on 2 separate occasions, resulting in ineffective communication in both instances. PGC is a public accommodation under the Maine Human Rights Act and is therefore obligated to provide reasonable accommodations to individuals with disabilities. Under the Maine Human Rights Act, PGC may only lawfully deny a reasonable accommodation request if it can demonstrate that the requested accommodation would result in either a fundamental alteration to the entity's programming or an undue burden. As a covered public entity, PGC is also subject to the ADA's existing regulatory framework on effective communications and reasonable accommodations, which in this context we refer to as auxiliary aids and services. The investigator's report correctly concludes that there are reasonable grounds to find that in July of 2023, PGC unlawfully discriminated against Ms. Sheikh in violation of the MHRA and the ADA when it refused to provide her with the auxiliary aid she specifically requested, resulting in ineffective communication at 2 of Ms. Sheikh's medical appointments. Had PGC provided Ms. Sheikh with her requested auxiliary aid, which in this case was an in-person or on-site American Sign Language interpreter, Ms. Sheikh would have been able to communicate effectively during her appointments. Ms. Sheikh has been deaf for her entire life. She understands her own communication needs better than anyone, and she knows which auxiliary aids will provide her with effective communication in which contexts. The applicable regulatory framework also recognizes that different contexts may call for different accommodations, and they hold entities like PGC to a high standard for ensuring effective communication based on these factors. The regulations not only require PGC to consider the nature, length, and complexity of communication based on context, but the regulations also mandate that PGC give primary consideration to a deaf person's requested auxiliary aid. In other words, PGC was required to honor Ms. Sheikh's requested auxiliary aid, again, an on-site interpreter, unless it could demonstrate that an equally effective means of communication existed or that the requested auxiliary aid would fundamentally alter its programs or create an undue burden. And as the investigator's report correctly concludes, PGC has demonstrated neither. Instead, PGC's position has consistently rested on troubling, irrelevant, and both factually and legally inaccurate claims that reflect a continued ignorance toward its obligations to Ms. Sheikh. For one, PGC has routinely stated that its ASL interpreters provided through VRI are, quote, medically qualified. I'm not sure where PGC is drawing this conclusion from, because the VRI service provider that they contract with states on its own website that medical certification is not a requirement for its pool of interpreters, and no such medical qualification is even available for American Sign Language interpreters. Spoken language interpreters may seek medical certification, but no comparable qualifications exist for ASL interpreters. I believe this continued ignorance is also reflected in opposing counsel's comments about needing to continue this hearing. The interpreters that we have for this hearing do have a specialized legal certification. That is not the case for medical interpreters. So the pool of available interpreters in the state of Maine for medical appointments is much larger than the pool that is available for legal proceedings such as this hearing. PGC's additional continued insistence that it may accommodate a deaf person like Ms. Sheik using VRI and VRI only is reductive and misleading. The regulations do not, as PGC suggests, endorse a VRI only policy, nor do the regulations permit PGC to provide VRI in circumstances where it would fail to ensure effective communication, as in Ms. Sheik's experience. Instead, the regulations acknowledge, when appropriately read, that in some circumstances, VRI may be an appropriate auxiliary aid so long as it results in effective communication. But the record here demonstrates that Ms. Sheik was not able to communicate effectively at her appointments. During her appointments, PGC's VRI equipment suffered technical issues like freezing and glitching, which disrupted Ms. Sheik's access to communication on a number of occasions and prevented her from being able to seek clarification from her medical providers or ask questions about things like her preoperative instructions. Consequently, she could not understand the full breadth of what her medical providers were trying to communicate to her, including, for example, the details of those preoperative instructions, and this caused her increased stress and anxiety about her upcoming procedure. Then, on the day of Ms. Sheik's actual procedure, she experienced a number of additional difficulties posed by PGC's VRI equipment, which again prohibited her from being able to communicate effectively. Ms. Sheik's prior filings describe these difficulties in greater depth, but one issue that I think especially exemplifies Ms. Sheik's inability to communicate effectively was the physical positioning she was required to lay in preparation for the colonoscopy procedure. Because PGC's VRI was connected and streamed through a small stationary digital screen in the room, the VRI interpreter had a limited visual window and could not see Ms. Sheik in full, nor her hands when she tried to sign to communicate. In return, the way that Ms. Sheik needed to lay down meant that she also could not see the VRI screen appropriately in return. These limitations prevented her from being able to access the VRI interpreter to connect and communicate with her medical providers effectively, and this again created increased confusion and anxiety, leading into an already stressful and very invasive medical procedure. In support of its position, PGC lists the DOJ guidance document that opposing counsel was just referencing, which is entitled ADA Requirements Effective Communication. And it uses this document to suggest that PGC did not discriminate against Ms. Sheik by providing her with VRI instead of the on-site interpreter she requested. However, as opposing counsel stated, this guidance document clearly states that, quote, VRI will not be effective in all circumstances. And it goes on to, as opposing counsel said, specifically reference situations where a deaf person may have difficulty seeing a VRI screen because, quote, he or she cannot be properly positioned to see the screen. And this guidance then concludes that, quote, in these circumstances, an on-site interpreter may be required. It's the same document opposing counsel just referenced. Ms. Sheik has also cited the Centers for Medicare and Medicaid Services 2024 final rule, which also explicitly states that, quote, policies requiring the exclusive use of VRI are likely to result in the eventual failure to provide effective communication and therefore should not be adopted. PGC is aware that it must comply with the applicable regulatory framework. And in light of the regulations and this related guidance, it is untenable for PGC to suggest that its sole reliance on VRI and its corresponding refusal to provide Ms. Sheik with an on-site interpreter for her medical appointments complied with its regulatory mandate. The entire spirit and purpose of these regulations and the applicable law is to ensure that entities like PGC provide deaf individuals with communication that is just as effective as communication with non-deaf individuals, and the record shows that PGC failed to meet this obligation. Opposing counsel makes additional arguments such as that Ms. Sheik did not provide a record of an unusual patient need, but I'll note that the regulations do not require Ms. Sheik to demonstrate any special or unusual patient need, and this reading of the regulations incorrectly burdens Ms. Sheik with almost a burden of proof that exists nowhere in the regulations. and that does not recognize that the regulations only obligate PGC to ensure that it is providing effective communication with the appropriate auxiliary aids, taking into account those factors I mentioned earlier, the nature, length, complexity of communication, and giving primary consideration to a deaf person's requested auxiliary aid or service, in this case, an on-site interpreter. PGC's reliance on generalized presumptions about patient satisfaction is also misplaced and irrelevant. The regulations and applicable law require an individualized inquiry into Ms. Sheik's accommodation request and require PGC to demonstrate, again, that it either would provide an accommodation that would promote equally effective communication or that the requested aid would result in a fundamental alteration or undue burden, and none of these have been proven by PGC. In sum, the record demonstrates that PGC discriminated against Ms. Sheik when it denied her the on-site interpreter she requested, resulting in ineffective communication on 2 occasions. PGC failed to give primary consideration to Ms. Sheik's requested auxiliary aid and relied on its VRI-only policy in deciding which accommodation it believed was best for Ms. Sheik based on its own personal assessment. In denying Ms. Sheik's request for an on-site interpreter, PGC did not provide Ms. Sheik with equally effective communication, and it has never demonstrated that providing her with an on-site interpreter would result in the fundamental alteration or undue burden. They have not met that standard. Therefore, as the investigator's report rightly concludes, there are reasonable grounds to find that PGC discriminated against Ms. Sheik on the basis of her disability in violation of both the Maine Human Rights Act and the Americans with Disabilities Act. Thank you.
Commissioner, questions for Attorney Decker? Commissioner Douglas.
Yes, Attorney Decker, good morning.
Good morning.
So the respondent's position is that any issues during the encounter were sort of temporary, right? There are some temporary glitches, and ultimately the complainant was sort of caught up on things in terms of what was going on. So there's a glitch, and then post-glitch things are explained, if I'm understanding correctly, and the complainant is sort of back up to speed. So I'm looking at 28 CFR 35-160, and I'm just wondering, because I'm looking at the requirements here, is that, assuming that the service provided by respondent sort of satisfies the requirements in subsection D here, right? Does a temporary glitch, does that constitute a denial of access, in your opinion?
I think this is an important distinction to be made, so I appreciate the question. The freezing and glitching is one of only several issues that Ms. Sheik identified with why VRI did not provide her with effective communication in the context of her medical appointments. I think it would be inaccurate to say that these were just temporary glitches that caused only a minor disruption in Ms. Sheik's communication. And I would point to PGC's own answer, which reflected a medical note stating that Ms. Sheik, not during the course of her preoperative appointment, but after that appointment, ended up having to call her medical provider back to get clarification about her preoperative instructions. So it is not as though PGC was able to remedy those problems and preserve perfect communication after a temporary glitch during that initial appointment. I would say the issue was more profound than that, and again, only represents one of several issues that Ms. Sheik experienced with the VRI equipment. Others including the positioning that I mentioned, which prevented her from being able to see the VRI interpreter, a VRI interpreter's inherently limited visual and auditory scope, making it challenging to capture every single thing that's happening in a busy operation room in a way that an on-site interpreter would not be able to. These are additional difficulties that Ms. Sheik has identified and that are also reflected in the record. So I hope that answers your question, and thank you again.
Well, it certainly is illuminating, and I appreciate that. So I'm looking at respondent's submission. And there are no page numbers here, unfortunately, but I'm just going to read from a paragraph. I'm sure you'll figure it out. Complainant lastly argues that there was some freezing, quote unquote, of the VRI transmissions during the pre-op meeting and again at the time of the procedure. This was factually disputed in the affidavit of Nurse Milo and the written statement of the third-party translator, AMN, whose records did not reflect interruptions and loss of service. Importantly, when pressed by the investigator on what was lost in communication by the VRI interruption due to the claimed freezing, she conceded that the freezing only required her to get clarifications during the sessions, which allowed continuing effective communication. So just so we're clear, you dispute that. You think there's more to it than what's set forth here.
Ms. Sheik did respond to that point in a supplemental memo that she submitted back in March to the commission. I would note that Ms. Sheik is a Native American Sign Language user and is therefore best equipped to pick up on and recognize difficulties in interpretation. To my information, the nurse who was working with Ms. Sheik that day is not a native signer and therefore may not have had the skill or understanding to notice the same interpretive difficulties that Ms. Sheik would inherently pick up on as someone who relies on American Sign Language to communicate effectively. I think that is potentially an explanation behind that miscommunication in the medical notes. I would also note that although ideally medical notes perfectly reflect what happens during the course of a medical appointment, it's very often the case that there are issues that are not actually reflected in medical notes. And so it's very possible that Ms. Sheik's complaints were either not communicated appropriately to the nurse, given the very interpretive difficulties that Ms. Sheik has identified with the VRI, or that they were simply not recognized by the nurse working with her for the aforementioned reasons, and therefore not identified in the medical report following Ms. Sheik's meeting. I would also, again, just clarify that Ms. Sheik did not have the opportunity to clarify or ask her questions to the full extent needed to understand her preoperative instructions during that actual appointment. She, again, needed to call PGC's office using VRS, which is a separate form of telecommunications equipment, in order to clarify that question in advance of her medical procedure to ensure that she had full and appropriate understanding, which she did not have during that initial pre-op appointment.
Thank you. And just for my own clarification, is part of the issue here from your perspective the sort of default VRI policy the respondent uses, as opposed to having a policy that's, in person with an accommodation to be made for VRI if necessary? Am I understanding correctly? That's part of your position here?
If I'm understanding your question correctly, it is our position that PGC's practice and policy, which to my understanding solely permits use of VRI, given their immediate denial of Ms. Sheik's request for an on-site interpreter, would not align with its obligations under the regulations and the guidance that I've provided earlier. There's significant references to VRI only policies that I listed earlier being almost sure to result in a failure to provide effective communication at some point. And what the regulations do specifically list is that need to take into account the factors I listed: nature, length, complexity of communication, and the primary consideration component. VRI, again, under the regulations, is only an applicable and effective alternative communication if it successfully results in effective communication. It is not an approved accommodation when it fails to provide effective communication.
And you think that respondent's policy violates 35160? I
do. I believe that a policy that requires VRI only inherently does not provide primary consideration to an auxiliary aid or service that is an on-site interpreter, which is what the regulations require. It by nature provides no consideration to the auxiliary aid requested by someone like Ms. Sheik in this circumstance.
Okay, thank you very much.
Tom, I'm going to direct you to our regulations instead of to the CFR. If that's possible. So
That's not possible.
well, I'm just asking. So our public accommodations rule talks about auxiliary aids and services, and what it says is, in addition to making reasonable modifications to policies and practices, a public accommodation must provide auxiliary aids and services when necessary to ensure that no individual is excluded, denied services, segregated, or otherwise discriminated against based on disability. Auxiliary aids and services may include, but are not limited to, sign language interpreters, foreign language translators, braille text, or reader or taped reading of material. In the case of a private entity, the private entity need not provide the requested auxiliary aid or service if it demonstrates that doing so would fundamentally alter the nature of its goods, services, or accommodations. I am done with my dramatic reading.
Thank you so much.
I knew you'd love it.
Yeah, and I did love it. Yes. Thank you.
Any further commissioner questions for Attorney Decker? Commissioner David?
Yes, Attorney Decker, you said several times that the result of the VRI was ineffective communication. What is the evidence that it was ineffective?
I would say pieces of evidence that indicate that it was ineffective was that Ms. Sheik did not have a full understanding of her preoperative instructions, was not able to ask her clarifying questions or communicate effectively with the nurse that she met with during that preoperative appointment. And then during the actual procedure, similarly, was not able to communicate effectively with her medical team on that day as well. One of the other issues I haven't touched on, but that has been referenced in Ms. Sheik's prior filings, is that by nature of her physical positioning, the VRI machine was on one side of her body, which required her to keep her gaze tied to that small digital screen, while on the other side of her body, the part of her body she could not see if she was to see the VRI interpreter to the best of her abilities, were nurses and doctors sort of maneuvering her arm, placing an IV, things of that nature, things that increased Ms. Sheik's anxiety, her stress when she was struggling to understand what was happening on her body when she could not see it, had that disconnect from the interpreter, which she couldn't see very well, and therefore just felt very disjointed from her medical team. And that increase in stress and anxiety inhibited her ability to understand not only what her providers were saying to her effectively and fully.
Attorney Decker, you're saying it increased her stress and anxiety. She testified to that in the hearing? I thought to the contrary, what Commissioner Douglas just cited to you was that she said, no, there wasn't any. In the hearing in this case,
That is not an accurate reflection of what has been presented in the record. Everything from Ms. Sheik's initial statement of particulars through all of her reply and supplemental memos indicated that she experienced not only stress and anxiety as a result of the difficulty to communicate, but then did not have the complete ability to ask her questions to her medical providers, to understand what her medical providers were saying to her in return in full, things of that nature. So to the extent that that's contested, I would say yes.
it certainly had an opportunity to say what she wanted to say at the hearing in this case with the investigator, correct?
Yes, Ms. Sheik was provided with interpreters to enable her to be able to
Okay.
communicate effectively, yes.
You do agree that she does not have any other disability that's added on to the language impairment, the deafness that requires sign language. In other words, there's no other contributing factor to that would be a special
Yeah,
circumstance.
deafness is not a language impairment. She does have deafness, which is a per se disability under the Maine Human Rights Act,
Okay.
and therefore is a primary user of American Sign Language. That is her first language. English is her second, not primary language. Yes.
Everybody agrees that if there was some other need other than the sign language, that would be a special category and it might require an in-person interpreter, right?
I don't believe that everyone agrees that. I don't think that's an accurate understanding of the applicable law. What the law says is that PGC is required to give the requested accommodation unless it can provide an accommodation that is equally as effective, and it has that burden to demonstrate that the alternative accommodation that it would like to provide Ms. Sheik with is equally as effective for ensuring communication as the accommodation that Ms. Sheik requested. Whether or not Ms. Sheik has multiple identity disability labels is not at all relevant to the legal and regulatory analysis applicable to this case.
Is it not the case that your argument is saying that if she requests an in-person interpreter, she's entitled to it?
My argument is exactly what is included in the regulations, which is that when Ms. Sheik requested an on-site interpreter, that creates a burden for PGC to provide that requested auxiliary aid or service, again, unless it is able to demonstrate that its alternative accommodation would be equally as effective. And for all of the reasons included in the investigator's report, PGC did not demonstrate either that its accommodation would be equally as effective or that it would create that fundamental alteration or undue burden.
We continued this case in May because of the unavailability of an interpreter.
That was the unavailability of a legal interpreter. There are a handful of those available in the state of Maine. Interpreters in American Sign Language may only function as legal interpreters if they have the proper certification to do so. That is not the case for medical interpreters, and therefore the pool of available medical interpreters in the state of Maine is much larger than the state of legal interpreters in Maine.
I think you may have answered this question. She had the preliminary interview, which is a special accommodation in the normal procedure of the setting up a colonoscopy. She had that, she had further questions, and she had another interaction with the practice. How was that interaction done?
That interaction is the actual colonoscopy procedure, which I've referenced a few times in my presentation.
No, there was another one after the pre-op conference.
Yes.
She had questions. How did she interact with the practice?
I think, Attorney Decker, that Commissioner David is referring to what you've already explained about the phone call.
Oh, thank you. I appreciate the clarification. Yes, so between the preoperative appointment and the actual colonoscopy appointment, Ms. Sheik called the practice. She called the practice through her video phone, which is a telecommunications device provided under Title IV of the Americans with Disabilities Act that enabled her to ask her follow-up question.
Were her questions answered?
Were her questions answered? Was that what you said?
Yeah. What was the communication ineffective?
The communication on the call that Ms. Sheik placed using her own personal video phone was effective. I would like to make sure that we are not conflating VRS with VRI, however, because VRS is a federally funded telecommunications program. And because it is federally funded, there are very stringent requirements around when VRS may and may not be utilized. And one of the primary rules for utilizing VRS is that it cannot be used as an accommodation in a setting such as a medical appointment where the medical provider and the deaf individual are in the same room. So what we are talking about there in terms of Ms. Sheik's personal phone call to the practice using VRS, that federally funded telecommunications program, and her ability to communicate with PGC using PGC's private personally provided VRI program, which is not approved by the regulations as a blanket policy, nor subject to those federal regulations around VRS. Those are two separate things. So I just want to make sure we're not conflating those as being the same form of accommodation.
My question was, were her questions answered? Was the communication effective?
Yes, using her
Thank you.
VRS equipment, she was able to answer her questions.
Several times you referred to the issue of positioning. Are you saying that she had a right to have an on-site interpreter in the procedure room?
In our issues and resolutions conference, PGC did say that there is room in the preoperative appointment in the lead up to the actual colonoscopy and after the actual colonoscopy for family members, things of the like. So yes, it is our position that Ms. Sheik's requested auxiliary aid and on-site interpreter, she would have been entitled to that during those segments of the procedure. Of course, I understand during a medical procedure, Ms. Sheik is going to be under anesthesia and not able to have additional bodies in the room. That is, of course, not what we are saying she needed access to. But in the moments when she was awake and there are available opportunities to have another body in the room, then yes, that is when it would have been appropriate for PGC to provide her with the on-site interpreter she requested.
What do you say about the concern that these procedures are scheduled 60 and 90 days out? And if you had a cancellation or a problem getting the interpreter with that extra layer of scheduling, that you would be winding up delaying procedures to the detriment of patient care on a routine basis?
My first answer to that would be that sort of generalized statements like this are not really relevant to Ms. Sheik's particular circumstances. The regulations and applicable law require this individualized assessment based on Ms. Sheik's individual circumstances. I think
her individual
Commissioner David.
circumstances.
Please stop interrupting. It's making it very hard for both us and the ASL interpreters to follow what's going on.
If I may finish answering that question, I think that the nature of the fact that these appointments are scheduled weeks in advance actually lends credibility to the idea that PGC should be able to secure ASL interpreters during those appointments. And Ms. Sheik did indicate in her prior filings that she understands, as someone who uses ASL interpreters in her daily life, that sometimes there are last-minute changes that need to be made. And given the particular context, given perhaps the importance of the medical appointment, things of that nature, she would be understanding potentially of needing to postpone or delay a medical appointment if absolutely necessary. In this particular situation, that delay did not make sense. Ms. Sheik was under the impression she would be provided with the on-site interpreter that she had requested. And without being gruesome, of course, this particular procedure requires a few days of preparation. And so having done all of that preparation, she decided to go through it with the appointment. But I think the fact that appointments are scheduled weeks and weeks in advance actually cuts against PGC's argument in terms of having difficulty scheduling ASL interpreters. That's ample time to get someone from the available interpreting agencies.
Well, that's all.
Any further questions for Attorney Decker? Okay, seeing none, you'll have about 3.5 minutes when we come back to you.
Thank you.
Attorney Remmel, you have 1 minute left if there's anything you'd like to add.
Well, I think that it's pretty clear now what the issue is, that Ms. Sheik is saying on a per personal subjective assessment, she thinks that the practice has to meet that personal subjective assessment by providing her an in-person ASL interpreter. And I don't think that that's consistent with the way the law and the regulations and the guidance is written. So I think that issue is relatively clear. Her position, in fact, would make parts of the regulation kind of redundant, because there's a whole part about what is VRI and how do you use it and what is satisfactory and so on. If you could just sidestep that by saying, well, I don't really care about that, I want to have it in person, that would be a problem. The only question that she called back for, getting too far into the weeds here, is
that is your time, Attorney Remmel.
If anyone wants the answer, I'll happy to provide it.
Any commissioner questions for Commissioner Douglas?
You want to finish your statement?
Sure. She called back, when you have a routine colonoscopy, you have to drink all these liquids and so on and so forth to clear out your bowel. And she called back with a single question that said, once it's clear liquid coming through, am I done? And they said, yeah, that's fine. She didn't understand. Did you have to keep drinking the stuff after you had the effect of it? So that was her one question, which was answered.
Okay. So first, I'm not sure I needed all that, but anyway.
I'm sorry.
Yeah, sorry. This case is a little different though, right? I mean, you just characterize it as, you know, complainant's got an objection to the, you know, the VRI policy, sort of VRI first. What I'm reading in the report here is that she had multiple appointments before this one where VRI was used, right? And she had issues with that. And then she requested accommodation, right? Having somebody in person. So it's a little different from that. It seems like she sort of rolled with the policy for a while, right? Felt like it didn't work and said, I need somebody in person because this hasn't worked in the past. So it's a little different.
Well, let me clarify that. There were two appointments. One is the pre-op meeting. When she first filed her written submission, she didn't say anything about requesting an in-person thing. Later on in the record, she said, oh yeah, I called ahead and asked for it. So I want to be fair to what the record said, even though she didn't say it in her written submission. In fact, she said she went and then found that this VRI was being used and didn't like it. And I think it's fair to say she said, I'd like to have an in-person VRI, an in-person translator when I have the actual procedure. So she didn't get that because of all the reasons that we've articulated, and that the fact that we think we're in compliance with the regulations and so on. Plus, trying to do that is where we get to the nub of the problem. What are medical practices around the state doing? What are they required to do? If we're going to start saying that a subjective assessment, which is using Ms. Decker's word, the subjective assessment of what I want is enough to overcome the accommodation that's being provided through VRI, then where are we? And that's the problem that's created. Right now, the practice throughout Maine and the country for medical practices is to provide this service by VRI. And that's considered to be appropriate under the law and regulations. This is a request to use the commission's discrimination policy to create a new policy where you can get an in-person ASL interpreter on demand. So that's where we are. I think the issue is fairly clear. Hope.
Any other commissioner questions for Attorney Remmel? Seeing none, thank you. Attorney Decker, you have about 3.5 minutes.
I would only echo what I've said previously, which is that Ms. Sheik's position is exactly what the applicable law and regulations require, which is that she requested a particular auxiliary aid, an on-site interpreter, and PGC is obligated to provide that requested auxiliary aid unless it can demonstrate that its alternative accommodation was equally as effective, which PGC has failed to do in the record throughout. It also has failed to meet its standard to demonstrate that providing the on-site interpreter requested would serve as a fundamental alteration to its programs or an undue burden. It is not accurate to say that the regulations unilaterally approve some nationwide policy for healthcare providers to use VRI and VRI only. The applicable law and regulations require that communication be as effective with deaf individuals as it is with non-deaf individuals, and that this requested auxiliary aid be provided unless its alternative is going to be equally as effective or fall under those other defenses, which PGC has not proven throughout the course of this investigation. So I appreciate the commission's time and welcome extra questions if there are any. Thank you.
Any other questions? Yes, Commissioner Douglas.
Yes, maybe like one. So Attorney Remmel just basically said that what you're advocating for is a policy whereby, you know, hearing impaired folks can just demand an in-person interpreter and sort of bypass a VRI policy on demand, were his words. And I don't think that's what you're advocating, but I wanted to give you a chance to respond to that.
I appreciate that. That is, in fact, not what Ms. Sheik's claim represents, nor is it the position that we are advocating. What we are advocating is for PGC to abide by its obligations under the applicable legal landscape and regulatory landscape, which is to provide effective communication to deaf individuals. Ms. Sheik, as you identified, Commissioner Douglas, experienced difficulties with PGC's VRI equipment, both in her past life, but then again during her preoperative appointment, which is what prompted her, as reflected in the record, to call again in advance of her actual colonoscopy procedure to make her request for an on-site interpreter, given her inability to access effective communication with VRI in her own interactions with PGC during that initial appointment. And so all that Ms. Sheik is requesting is for this commission to acknowledge that there are reasonable grounds to find that she was discriminated on the basis of her disability, given PGC's failure to provide effective communications in line with the regulations and law that it is subject to, on the basis of her disability of deafness.
Thank you.
Any other questions for Attorney Decker? Seeing none, next we will hear from Carrie McCarter, the investigator assigned to this case.
Hello, my name is Carrie McCarter. I was the investigator assigned to this case for the commission. The parties presented their case here, as they did to me. As far as what the respondent would be required to show, that is on page 3 in the failure to provide a reasonable accommodation analysis. Upon such a showing, respondent must make the modification unless it proves that doing so would alter the fundamental nature of its good services, facilities, privileges, advantages, or accommodations, would impose an undue financial burden, or that the requested modification poses a direct threat to the health or safety of others. They did not show that here. And I'm happy to answer any questions.
Commissioner, questions for Investigator McCarter? Commissioner David?
Carrie, what you just said referred to financial burden. Is there any evidence of the where the financial burden lies in hiring a in-person interpreter?
I don't believe they argued that it was an undue financial burden.
But does the burden fall on them?
Yes, as the public accommodation, they are the ones that would have to provide that, and they would have to show that they cannot provide that.
Okay.
Any other commissioner questions for the investigator? Seeing none, thank you, Carrie. We've heard from the parties and the investigator. At this time, we are looking for a motion. There is one proposed finding.
I'll move that we adopt the investigator's proposed finding and finding there are reasonable grounds to believe that the respondent discriminated on the basis of disability and conciliation to be attempted in accordance with 5 MRS 4612 subsection 3.
Okay.
Awkward.
I'm waiting to see, Julie, are you unmuting yourself or you're just, no? Okay. I have a feeling you're going to have to in a minute. So it seems like this motion is failing. Somebody want to make another one?
Someone has to think.
We got to have some motion.
I think
Okay.
Done my part.
I'm trying to find the wording, but go ahead, Ed. I can't find the wording.
I'll move it.
Okay, got it. Okay. I would move that there are no reasonable grounds to believe that Portland Gastro Center discriminated against Satara Sheikh on the basis of disability, and conciliation should be attempted in accordance with 5 MRS.
Julie, I think you mean and the complaint should be dismissed.
What
You
does
want
it
to
say?
do conciliation if it's a no reasonable
Oh, I'm
grounds.
sorry.
Yeah.
Thank you. Should be dismissed in accordance with 5 MRS 46123.
Second.
Moved and seconded. Is there any discussion?
Yeah, I just want to say that I can clearly say that there would be situations in which someone who had the need for the sign language interpretation had another condition that put this in a special category. And I don't find that here. I'm hearing that her questions were adequately answered. I think it would be a huge burden to require this basically upon the person that uses sign language saying, I'd like to have an in-person interpreter. And I'm very concerned about going out on the limb and putting, saying that that's discriminatory animus to not provide that.
Agree.
Yeah, I mean, I get that this is a test case. It's been made clear by the materials and the presentations. And yeah, I just think that, and here in this case, right, we have somebody who had at least one appointment, right? Claimed that the VRI was not effective, and then asked for an in-person interpreter. And we've heard nothing about a financial burden or hardship, really, from the respondent. I think that the arguments about the regs and so on are compelling, and we spent some time on those, but I just don't, I think that where somebody makes a showing, and I think that complainant's counsel credibly argued that, her client didn't understand the pre-op instructions. The RI was on one side of her body, so there wasn't always the communication, maybe the medical providers on the other side, and it wasn't equally effective. And so she has these difficulties, and then she asks for the reasonable accommodation, for which I haven't heard much about a burden. I mean, I guess we can imagine, right, that to have somebody in person there, as opposed to having a VRI, I guess, maybe that is more difficult under certain circumstances, but I don't know that we heard that. So I think it's a close case, and I think that it was well presented, but I think I think that there's an even chance that this discrimination claim could prevail. So
I hear you, Tom. I think that given the state of the regulations, those need to be changed, and that policy issue needs to be vetted, considered, and changed with more intentionality than this individual case, which I don't think has any special circumstances. And I think it boils down to her position and saying that this is a poor test case, and I think it fails as a test case.
Any further discussion?
I think it's about to fail as a test case. So.
So the motion is to find no reasonable grounds. If you're in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
No.
Okay. So the findings are no reasonable grounds. The commission will send a letter to the parties confirming the results of the hearing, and we appreciate everyone's participation. In particular, thank you to the interpreters for being here. I would like a 5-minute recess.
Okay. So be it.
Pardon me, Kit, this is one of the interpreters speaking. Can you hear me okay?
Hi, Amanda. Yes,
The interpreters to continue interpreting until 10:30, or are we free to go? Thank you.
What's that, Kit?
I was just letting Jeremy Carter, who is the AHE in PA 240248. I was just letting him know that we had just finished the first case, and so if he wanted to go back to his office for a couple of hours, that would be fine. And I'll let him know when we're at the case before his.
So we'll take the.
We've got a full room today, so there is not a lot of seating available.
Okay. So the next case for hearing is E24-0185 Wayne Davis versus Augusta Public Schools. The recommendation from the investigator is for a finding of reasonable grounds on one count, and therefore we would hear the presentation first in objection from respondent.
Kit, I need to recuse myself from this one.
Well,
Okay.
you can't recuse yourself because we have no quorum.
It's okay.
Oh.
It's okay.
It's okay. Hang on, Barbara's thinking.
We have a quorum of people present.
Right, that,
Okay.
So it still counts.
All right. Okay.
that's what I was hoping. That's what,
So
okay.
you were recusing yourself,
I
Julie?
don't have Roberts in front of me, but I'm pretty sure that's correct.
I think we have done that in the past.
Yeah, I know we have.
Yes.
So
we
I'm
have.
at least being consistent if I'm wrong.
Well, it's the commission's rules if it's not Roberts. So, okay, Attorney Wergeff, if you're comfortable with that, we'll proceed.
all right.
Okay.
Thank you very much. Good morning.
Attorney Young, I guess I should ask. Attorney Young, are you comfortable with that also? Okay, great. You have 10 minutes. when
Thank
you'd like
you.
to start. Do you want to reserve any of your time?
I'll reserve whatever I have left.
Okay.
I'm sorry. I don't think you heard me say yes. My audio was off.
I didn't, but I
Was
saw
not.
you nodding.
Okay, very good. I'm gonna keep my audio off until, yeah.
Good morning, Hannah Wargaft. I'm attorney at Brandon Isaacson. I represent the Augusta School Department. This is a case where the employer did the right thing. The school department hired the complainant, Mr. Davis, as the food service manager of the cafeteria. He managed the cafeteria staff, a relatively small group of mostly women. And within the first 6 months of his employment, the school department realized it had a supervisor who got into shouting matches with coworkers, refused to do certain tasks because they were below his pay grade, and openly compared his staff members to one another. In his filings, Mr. Davis refers to his subordinates as his underlings and says they whined about him to his supervisor for holding them accountable. In fact, he was so harsh that he made women cry, and 2 women that he supervised moved to other school buildings so they wouldn't have to work with him. Under the collective bargaining agreement, the first 6 months of employment are probationary. After the first 6 months, employees can only be terminated for cause. They're effectively tenured, and that for cause standard does not apply the first 6 months. So towards the end of that 6-month probationary period, the school district faced a decision: retain him or let him go. And based on his unprofessional and disruptive conduct in those first 6 months, the school department decided to let him go. Frankly, the irony here is that if the school department had ended Mr. Davis's employment at that time, it probably would have faced a harassment or discrimination complaint from another employee within the school district due to his behavior. But no good deed goes unpunished, and instead the school department faces this whistleblower complaint from Mr. Davis. Now, the investigation report states that there are grounds to believe the school department retaliated against Mr. Davis for 2 main reasons. First, the timing, and then also a lack of evidence from the school department of Mr. Davis's performance issues and any constructive feedback given to him. First, on the timing issue, the report states that the timing of the termination creates a strong inference of retaliation. The fact is that Mr. Davis's probationary period was about to end, and that's what drove the timeline. Again, after the probationary period, he would effectively become tenured and could only be terminated for cause. Again, that standard is not applicable during the probationary period. He was terminated the Friday before the probationary period ended. And again, that's just what drove the timeline. The report references an alleged argument between Mr. Davis and his supervisor 2 weeks before his termination, where Mr. Davis allegedly refused to serve expired hamburger meat. Plain and simple, there is no evidence of an argument on the record. There are contemporaneous emails from that day documenting communication between Mr. Davis and the supervisor, and the contemporaneous emails do not support Mr. Davis's version of events. Second, the report states that the school department has failed to provide evidence of Mr. Davis's performance issues and any feedback given to him. Frankly, the school department has produced this evidence, and respectfully, it's just not reflected in the report. The first are contemporaneous notes from Mr. Davis's supervisor documenting a conversation that she had with one of his staff members, a woman. And the notes indicate that this woman, who I'll refer to as LM, was sobbing in the kitchen, was very upset, came to speak with the supervisor, and again was extremely upset, sobbing in the supervisor's office. She said she was nervous to talk to Mr. Davis, who was her supervisor. And again, the notes indicate that she described Mr. Davis comparing her to a male employee, saying something along the lines of, "You need to be more like Paul, you need to work as hard as Paul." I'm sorry. This employee, male employee, had worked in the cafeteria for nearly 20 years, and this woman, LM, had only been there for a week. The notes indicate that Mr. Davis had complained about this woman, LM, to his supervisor and said she was incompetent, untrainable, had horrible hygiene, was spacey, slow, and couldn't figure out how to work the register. Again, she had only worked there for a week at most, so these were extremely harsh conclusions for Mr. Davis to draw in just a few days. As stated in the notes, again, these are at Exhibit 3, the supervisor moved this woman, put her in an elementary school to gain confidence and improve her morale. I also want to note 2 affidavits from school department witnesses. These are Exhibits 17 and 18. One affidavit is from the facilities director, who recounts an incident where Mr. Davis screamed at a custodian and got into his face. The affidavit also describes the facilities director overhearing Mr. Davis bad-mouthing his own supervisor to the cafeteria staff, which made them uncomfortable. There's also an affidavit from the supervisor's assistant, so someone else that worked in the food services department, who corroborates that Mr. Davis refused to use the cash register on multiple occasions and said that it was below his pay grade. She also corroborates the argument with the custodian and corroborates that 2 women were transferred to 2 other buildings so that they wouldn't have to work with Mr. Davis. The evidence in these affidavits is not considered in the report. The report says the affidavits are not given any weight, and the report acknowledges that the school department submitted these affidavits, but then also states that Mr. Davis submitted 2 affidavits that reflect that he had positive relationships with employees, and therefore these affidavits cancel each other out. With all due respect, it's just not that simple. The affidavits can't be treated like offsetting fouls in a basketball game. The statements deserve analysis, and the school department witnesses particularly corroborate that Mr. Davis acted unprofessionally and disrespectfully while on the job. That elsewhere in the report states that the school department has provided no evidence of, but it is there. It's in the affidavits, among other things. I also want to mention a contemporaneous email from Mr. Davis's supervisor. This is Exhibit 16. On the day that Mr. Davis was terminated, the supervisor emailed the school principal informing her that he was being let go. And in the email, the supervisor says that she was disappointed. She had high hopes for Mr. Davis, and she was very disappointed that she had to let him go. We don't know if the investigator considered this email because it's not referenced in the report, and frankly, I think it should be. I also want to draw your attention to the complainant's own notes, which are at Complainant Exhibit 3. These are notes that Mr. Davis made after a meeting with his supervisor in January of 2024. And Mr. Davis's notes indicate that the supervisor counseled him about his interactions with staff and coworkers and counseled him about his insubordination in refusing to work the cash registers. The notes also indicate that he made women uncomfortable, including his own supervisor. In the notes, Mr. Davis wrote down, in quote, "Jody said one day I stared at her as though I was burning a hole through her. I have no idea what that means." Again, these are Mr. Davis's own notes that corroborate the school department's decision-making here. I do want to mention as well that during the course of this investigation, Mr. Davis has claimed that during that meeting, the supervisor discussed sending him to a professional conference. That is not captured in his own notes. Again, these are at Complainant Exhibit 3. At the end of Mr. Davis's probationary period, the school department frankly had a choice to make. And the fact is that if the school department hadn't terminated Mr. Davis, it would be standing here defending a gender discrimination complaint. It realized that a supervisor who did not treat people with respect, particularly women, and so the school department decided to let him go. The evidence in this case supports the school department's decision. This was not a pretextual decision, and frankly, there's no evidence of causal connection between Mr. Davis's internal maintenance complaints relating to issues in the kitchen and his termination. For these reasons, we urge the commission to find there are no reasonable grounds in this case, and with that, I'm happy to answer any questions.
Commissioner, questions for Attorney Borgast?
Yes, good morning.
Good morning.
Right, so appreciate your position. It seems that reading the submission that we have, conflicting facts here, right? You mentioned the offsetting affidavits, et cetera. Two things stood out to me, right? Looking at the investigator's report. The first is the subparagraph F. I'm just going to read it to you. It says, on January 25, 2024, director told complainant that he was performing satisfactorily and mentioned sending him to a food services conference later that year in August, right? So that's on page 3 of the investigator's report. And so at least if that is to be believed, right, as of January 25, he's okay, right? And he's going to continue on, understanding that his probationary period is about to end, right? And then, February, a couple of different things happened. One, the situation with the meat, and I read the emails. I agree that it doesn't seem like anybody was terribly upset about anything, right? Then there's this email on February 15 where the complainant emails and says, you know, we've got a problem with falsifying production records. I guess there was some request that he characterized that way. The lack of emergency lighting in the kitchen and the use of an extension cord on a wet floor, and there's no response. And then the next day he's discharged. So those things sort of stood out to me as, you know, something I'd like a little more information on.
Absolutely, sure. So I'll start with that email, which is the night before, I believe it's 9:07 p.m., the night before the meeting where Mr. Davis is terminated. What I would note, and what I don't think is reflected in the report, is that email went to the superintendent at the time, Mr. Jim Anastasio. I'm sorry, I should not be using names. I apologize. The superintendent who received that email was not involved in any performance discussions or in the termination. The current superintendent, who I will not name as I'm not using names, and I apologize, who's here today with me, was the assistant superintendent at the time and was working with Mr. Davis's supervisor throughout his employment regarding the performance issues, and they were the ones who made the decision to terminate Mr. Davis. So and the assistant superintendent testified to that during the Issues and Resolutions Conference. So I understand that there's an email the night before. I think the evidence is that there was no response to that email and that the superintendent had no involvement.
Email went to somebody other than the decision maker.
Yes,
that's what I hear you say. And then there's an Exhibit 3 here in the record that we received. I think it's actually attached to your submission.
Sure.
But I just wanted to clarify the date on that.
Sure. So yes, our Exhibit 3 are contemporaneous notes from the supervisor. My understanding is that these notes were made on or about Thursday, December 7th, 2023. So that's approximately a little more than 2 months before Mr. Davis's termination.
And then otherwise, the issues that complainant had with some employees and not others, your position is that was documented contemporaneously.
So my position is that the school department provided 2 credible affidavits from the facilities director and from the assistant within the food services department, and that their affidavits, the substance of their affidavits corroborates the performance issues and some of the incidents and encounters that gave the school department real concerns about Mr. Davis's continued employment. Let me just add that the Exhibit 3, which we were just talking about a few minutes ago, are contemporaneous notes. In the report, these are referred to as an affidavit. So I just want to be clear that this is not an affidavit. We've submitted 2 affidavits, which are at Exhibit 17 and 18, but Exhibit 3 are contemporaneous notes. And of course, one of the challenges in this case, I'll just be quite honest, is that the supervisor who made these contemporaneous notes is no longer employed at the school department. So she was not interviewed during the course of this investigation, unfortunately, which is in part why we're relying on contemporaneous notes, which they're contemporaneous, were made at the time, and we would submit are credible.
Gotcha. So other than these notes, any other documentation of complainants' issues with sort of employee relations, et cetera, before he's terminated?
Well, again, I would point to his own notes, which he's provided in the record, which document that he was counseled about a number of these issues about a month before his termination. At the Issues and Resolutions Conference, the assistant superintendent also testified to having numerous conversations with the supervisor about his performance over the course of those first 6 months.
Thank you.
Sure.
Any other commissioner questions for Attorney Burgaft? Commissioner David?
I think you were just answering the the question, whether he was counseled. The investigator says respondent did not provide any evidence such as documented disciplinary actions or counseling notes to show that complainant exhibited a pattern of unprofessional or disrespectful behavior. Was he counseled? Was there any progressive discipline?
There was not progressive discipline. Again, the probationary period itself, frankly, was a reflection of, the termination at the end of the probationary period was a reflection of his performance. There were not any written counseling notes or performance evaluations documented within those first 6 months. Again, I would point to complainant's own notes, which he submitted, which memorialized that there was a conversation where he was counseled about his performance.
Well, this business of a probationary period has always troubled me. You would agree that being in that probationary period does not excuse the respondent's requirement to not discriminate based on whistleblower protection things, that if he's reporting things that are illegal or a safety concern or unsafe, that those would be appropriate, right? Those are not shield. In other words, the fact that he's on probation doesn't mean that they can ignore those.
Oh, absolutely not. No, absolutely not. Our position is that there was no causal connection between his reports and the termination.
All right. So what about all those specific reports? Is it your position that they're all addressed, the cord on the wet floor and the other safety concerns?
Yes, and I would say, those issues were litigated extensively or investigated extensively during the course of this investigation. There is quite a number of emails and various evidence showing that the school department took those issues seriously and acted to remedy each of those issues. I believe at the Issues and Resolutions Conference, Mr. Davis admitted that the school department did so, although perhaps not in the specific timeline that he would have liked, but nevertheless, they were addressed. It is a large school department, and there are always competing priorities for the facilities department, but each of those issues were addressed. I will mention as well that one of the reasons why I think those issues received so much attention during this investigation is because in the complaint, Mr. Davis alleged that he made all these maintenance requests to no avail. And that is just not accurate. The record clearly shows that the school department took each of these issues seriously, responded to him in each instance, and then acted to remedy each specific issue. So the fact that the allegation is that he made these complaints to no avail is just not accurate.
And the investigator, in fact, concludes that it's a close case and says that in her own mind, it comes down to the commission's standard of an even chance at trial. This is the stuff of trial, whether or not he could prevail on introducing that evidence or not. What do you say about that?
I'm sorry, I don't understand the question.
Well, that you don't think that there's an even chance he could prevail at trial?
No, I don't.
Showing all of these complaints and what the actions were and that kind of thing? No? Okay.
No, I think when you really dig into the credibility analysis of the complainant and of the school department's witnesses, that no, I don't think the complainant, respectfully, I don't believe the complainant has an even chance of prevailing.
Okay.
Any other commissioner questions for Attorney Wargast? Saying none, you'll have about a minute left when you come back to you.
Thank you.
Attorney Young, you have 10 minutes. You want to reserve any of your time?
Am I on live now? I just want to make sure.
You are. We can only see the top half of your face, though. There
How's
we
that?
go. Okay.
Okay.
Great.
Thank
Did you
you.
want to reserve any of your time?
Yes, I'd like to reserve 2 minutes. Thank you.
Whenever you're ready, go ahead.
Okay, thank you. Good morning, Chairman David and members of the commission. My name is Jeffrey Neal Young, and I represent Wayne Davis. For the reasons set forth in the investigator's report, the investigator should adopt the recommendation and find that the school department violated Maine's Whistleblower Protection Act when it terminated Wayne Davis on February 16, 2024. I can and will get into the 7 different safety complaints that Mr. Davis made during his tenure, but I wanted to first turn to some of the arguments made by my colleague. I think the timing of the termination is very significant in terms not of the probationary period, but of the fact, as the investigator found in her report, that at that meeting on January 25th, despite some discussion of issues, that he was doing a good job and that she planned to send him to a conference. It was the following summer. So, and then we have the email to the superintendent rather, excuse me, the night before he's terminated. I don't believe there's anything in the record suggesting that there was a plan the night before or until the day of the termination to actually terminate him. The superintendent, who would have been involved, or perhaps was involved, did not testify that he wasn't involved. And then, so the timing, I think, is important. The Hamburg incident, I wanted to turn to that for a moment. Mr. Davis, the emails do not tell the entire story. At the investigation at the IRC, Mr. Davis clearly testified that there was, about 3 weeks before his termination, a day-long dispute about the use of 400 pounds of hamburger meat that was 2 years expired, and that JF, the nutrition or director of food services, repeatedly tried to parry every attempt that he said to say, look, we can't use this meat because it's expired. JF tried to say first that they could do so, as long as it was less than a year. And he pointed out that it was 2 years, and this went on for the entire day, and the emails do not totally reflect the conversation. There was clear testimony and also in the charge about the dispute that happened after the statement in January that he was a good performer, and only about 3 weeks before the termination. As the defendant, or as my opposing counsel admits, although there may have been some discussion with Mr. Davis about some issues, there was never any progressive specific written warnings or anything like that, no progressive discipline during his employment. I wanted to talk next about the opposing counsel focused primarily on LM and LM's crime. But LM said, and this is a direct quote, "I'm just overwhelmed in general as I have stuff going on at home and feel incompetent at work." What was in the record and not mentioned by counsel was that LM's parent died during that week. So understandably, LM was had difficult emotional issues with that. And my client, Mr. Davis, did not tell her that she needed to work as hard and fast as a 20 male employee. And rather, what he said to her was that she should model himself after this 20-year employee, because LM was saying that she was overwhelmed and felt incompetent. So he tried to point her to someone who was competent. The second employee who provided an affidavit, LM was chronically late, was a poor performer, and even the food director described LM's food is quote unquote awful. I think if you look at and this is in the report, the statements in particular of the baker, who was the co-worker, who said the staff is all in agreement. This is the people that actually were there for more than a week, although it doesn't say that. The staff is all in agreement. Wayne has been a strong advocate and asset for the team. We appreciate his positive energy. And then you have the assistant principal, who submitted an affidavit and said that he observed Wayne Davis every day and said, I could tell that his staff cared for him and that he cared for them, and goes on to praise Mr. Davis's performance and attempts to improve things. So, yes, there may have been some short-term employees who submitted affidavits after the fact, but that's after the fact, and they do not reflect what the other employees were saying is reflected by the baker and by the assistant principal. I wanted to turn to these various complaints. I don't agree that Mr. Davis admitted that all of the matters were addressed or fixed. With regard to the emergency lighting and exit signs, as of the date of Mr. Davis's termination, he said that the exit signs had not been fixed, and he reported on multiple occasions it took 3 or 4 months to address a very serious concern about the emergency lighting. He complained September, October, November, and December 18th. That is an unsafe condition, and it was after that complaint, the last complaint, that JF, and this is in paragraph 2E of the investigator's report, that JF told Mr. Davis that, quote, your employment is going to end badly, end quote. I don't believe that the kitchen hoods were addressed. They, for till a long period of time, they kept turning off. He complained September 22, 27, 28, and October 2. The kitchen hoods not working properly results in carbon monoxide buildup, which can be dangerous to employees. There was falsification of production records, which JF took exception to. She wanted to have the meal tray counts match the
Attorney,
actual.
that is 8 minutes. If you'd like to keep going, I'll just keep the timer
Yeah,
running.
I'll wrap up here. There was the loading door malfunction, and I do want to point out that Mr. Davis disputes that he had any shouting match, but this was an ongoing issue with the director about that because of the lack of safety of theft, and this came up particularly after the Lewiston school shootings. The extension court, I don't need to say much more about. The dumpsters were attracting vermin and flies. So I think when you look at all of these factors, it's clear that it's at least an even chance, and I would say much better than an even chance, that Mr. Davis was terminated in violation of the Whistleblowers Protection Act. Thank you.
You'll have about a minute and 10 seconds left when we come back to you.
Thank
Commissioner,
you.
questions for Commissioner David?
Attorney Young, how do you respond to the statement that it's a probationary employment and that cause is not needed? That still bothers me.
Well, I'm sorry, did I interrupt you, Commissioner?
No, not at all.
No, I would say what you said in response to or your question rather, to my colleague, which is
Right.
that the fact that an employee is on probation does not shield the employer from having to obey the Maine Whistleblowers Protection Act. And in this particular case, there were complaints about safety right up until the day before he was terminated. So, with a lack of any progressive discipline here, I think that speaks volumes.
And it's your position that there was no progressive discipline, that this counseling was not with him or clear or effective in terms of
That
these issues?
that's a fair question. I suppose that a verbal discussion could constitute a review of performance, but I think it has to be put in the entire context of that conversation, which is the investigator concluded that despite those concerns, that on January 24th or 25th, I'm sorry, that JF specifically told my client that things were going well, that she was happy with his performance, and that she was talking about sending him to a conference. It was only after that that these additional safety concerns were raised.
It is after that?
Yeah, the situation involving the meet, the letter to or email rather, excuse me, to the superintendent were all after that.
Okay, discharged in February.
Yes,
Yeah, okay, thank you.
thank you.
Other questions for Attorney Young? Okay, seeing none. Attorney Wergaff, you have 1 minute and 16 seconds. Thank you.
Yeah, quickly, two things, just where my co-counsel left off on that January 2024 discussion between Mr. Davis and his supervisor. Again, there's this allegation that from Mr. Davis that his supervisor told him he was doing a good job. She was very happy with his performance. To be very clear, that is not captured in his notes. I would ask you to look at Complainant's Exhibit 3. He does not jot that down from that conversation. That would seem like something very important to jot down, and that does not appear in his notes. I also want to point out that in the email that Mr. Davis sent to the superintendent the night before he was terminated, the issues that he complains about, there are no new issues in that email. All of those issues he had already complained about to his own supervisor, to the facilities director. There's no new news in that email. So I don't believe that that should be considered as an independent report per se. Thank you.
Any commissioner questions for Attorney Wergaff? Thank you.
Thank you.
Attorney Young, you have 1 minute and 11 seconds.
I don't have anything that I think would be worth it. I think the issues are clear. Thank you.
There are no commissioner questions for Complainants Counsel. We will move to Nuper Leva, the investigator assigned to this case.
So I'll just let everybody know, Newper and I have been working extensively through this whole meeting. Her video is not appearing, and rather than try again during the case. So her face, we did try to get her face off the screen, but she can hear.
Nuper, you are muted.
Yep, thank you. I'm hoping everybody can hear me now. I don't really have much to add that hasn't been sort of said already by the parties. The parties have presented their cases to you just as they did to me. The only thing I want to note is that I did interview the current superintendent at the IRC conference. And during that conference, the superintendent told me that between the January 25th meeting and when complainant was discharged, he was not aware of any other performance issues that arose. And given the timeline and sort of the lack of any other disciplinary documentation, it felt very close to me. And given our 50-50 standard, I chose to see that this was just sort of an even chance case that could prevail at trial.
Commissioner questions for the investigator? Yeah, Commissioner Douglas.
Good morning, Newper. I'm just wondering the statement in your report about the January 25th, where complainant was told he was performing satisfactorily. Where does that come from? I'm hearing that notes do not reflect that statement, and I'm just wondering what's the basis for that statement in your report.
So for me, that statement definitely came from the complainant. I'm going through everything that I have to see if there's any other documentation, but most of that came from the complainant. There wasn't anything to refute that statement. There weren't any notes that sort of indicated that he wasn't performing well at that point, or that the statement that he told me wasn't true. So I determined that it was accurate.
Okay, and then did I hear you say the superintendent told you that between January 25th and his termination, there were no more performance issues?
Yes.
Okay, all right, thank you.
Any other commissioner questions for the investigator? Seeing none, thank you, Newper.
Thank you.
We've heard from the parties and the investigator. At this time, we are looking for a motion. There is one proposed finding. Commissioner David?
I'll move that we find that there are reasonable grounds to believe that the respondent retaliated in violation of the WPA and conciliation should be attempted in accordance with the statute.
Second.
You moved and seconded.
I agree that it's a close call, but that's the standard is that the close call goes to the complainant. I mean, this business about the probationary period, it seems as though they hurried up to get him fired before the end of the probationary period and get rid of the troublemaker. And the troublemaker is reporting violations that need to be attended to and paid more attention to than the record seems to reflect they got.
Yeah, I would just concur with Commissioner David. I just feel like, I think that there were a lot of compelling points raised on both sides. I think the bottom line for me is I don't know how this comes out at trial. I think that the complainant could prevail, and I think that the respondent, has some really good arguments to make as well. So I think this is an even chance standard case. So.
Any further discussion? Okay, seeing none, the motion is to find reasonable grounds. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
He's recused.
Oh, you're recused. It's like, why hasn't Julie unmuted herself? You're gonna have to have some more coffee today. Commissioner Douglas?
Yes.
Okay, so the findings are reasonable grounds. We will send the parties a letter confirming the results of the hearing.
The third case for hearing is E24-188, Dimitri Bowman versus Town of Old Orchard. The recommendation is for finding of no reasonable grounds. And I think it's just on one count. Therefore, we would hear from complainant first.
Good morning, Attorney Morris. Do you want to reserve any of your time?
Good morning. I'll just reserve whatever I have left.
Okay, whenever you're ready, go ahead.
Thank you. Good morning, commissioners. There's a couple of points I want to focus on. We've submitted obviously our objections to the report in writing, and from those objections is a couple of things I want to emphasize. First, our view of this case is that the report construes Mr. Bauman's protected activity too narrowly. His concerns weren't limited to a disagreement about ordinary work assignments or volunteer firefighting. Rather, they were public safety related concerns, emergency response responsibilities, inspection sign-offs, involving allegedly inadequate egress and smoke detectors, and the director's absence from inspectors. The second point I'd like to make is that the timing here supports an inference of causation. Mr. Bauman raised his concerns with the town officials in April of 2023, and then he received a written warning in PIP in June, and the town moved to discharge him in July. And so we believe that timing supports the inference of causation. And then finally, the third thing I'd really like to emphasize from the facts is what we would say is evidence of pretext. The PIP gave Mr. Bauman until September 16, 2023 to meet the requirements of the PIP, yet the town issued a pre-disciplinary notice on July 18th, cutting the PIP period short. So, In all, the lack of discipline before the complaints, restructuring confusion and delayed job expectation description, the disputed basis for the written warning, and the intervening acts, we would argue support a reasonable grounds finding here. I would ask that the commission vote to find reasonable grounds that a violation of the Whistleblower Protection Act occurred.
Commissioner questions for Attorney Morris? Commissioner Douglas, and then Commissioner David.
Morning, Sally.
Morning.
Yeah. What's this business about? I'm seeing something in the report about complainant missing several certifications that he was supposed to get. Can you talk about that?
Right. So when he was brought on, he was given a period of time to complete his certifications. Those were extended. And then in the PIP, the period of time to complete them was, I believe, through the September 16, 2023 date I noted. And then they moved to termination before that time period was completed.
Okay. All right. And the public safety issue, as I understood it, please correct me if I'm mistaken, is that he was not allowed to sort of respond to firefighter calls during regular business hours, right? He's hired as a code enforcement officer. He's supposed to function as a code enforcement officer, and he wants to respond to certain calls for assistance with the fire department. And respondent says, no, you have to work your code enforcement job during the regular hours. And your client is saying that's a public safety issue. Am I understanding that right?
Partly, I think.
Okay.
So he started with the town as a volunteer firefighter in 2011. And then he continued in that volunteer role. And what he was complaining about was the interference with his ability to fulfill that volunteer role and respond to calls as a volunteer firefighter. And then in addition, the other safety reports that we cite in the case is the unsafe inspection sign-offs, egress, smoke detectors, and those things.
Okay, thank you.
Commissioner David, and then Commissioner O'Brien.
Attorney Morris, what you just said was that he was a volunteer firefighter and he's complaining, and they agree that he's complaining about his inability to respond, and that's a public safety issue when he's told to work as the code enforcement. I mean, I can imagine that there's a whole world of response to calls, whether they are an emergency, whether they're actually a fire, whether there's a second alarm, whether it's a cat in a tree, and it seems to me that your argument saying that's a public safety issue and therefore within the scope of the WPA is too broad. Can you tell me what else he's alleging is within the whistleblower protection that he's reporting that he's being fired for?
Yes. I don't know if I completely understand what you're asking me. Are you asking me to respond to the question of the volunteer firefighter, or if there are other issues?
Yes, I guess I'm asking you to specifically focus in terms of that claim of public safety. If the town's position is not that you never respond to a fire. The town says if there is, I can't remember the wording, but if there is that escalated need for all hands on deck, as we said in the Navy, that's okay. But other than that, you stay at your code enforcement work.
Yeah, I guess the response to that is, what my client alleged was that he was told he could not respond, and so he was reporting that as raising a public safety issue.
And that's not what the respondent says. They said he could respond if it was that escalated need for for firefighters, right?
Well, I guess that's the respondent's position, and if
Yeah.
so, I guess there would be a factual dispute.
Okay.
Commissioner O'Brien?
Yeah, go
Oh,
ahead,
sorry.
Julie.
David-
No, go ahead, Julie. Yeah. You're on mute, Julie.
I apologize. I haven't spoken much today. I would like to go back to the certification issue. I understand that they gave him an extended time, but was that extended time that he needed to do 6 of the 7 different certifications? Was the extended time, did that include all 6, and did he do any?
Yeah, so looking back to the complaint, we allege, or the statement is that he had 2 courses left to complete by September 16th, 2023.
Okay, so he didn't complete 2 of them, correct?
Well, he was terminated before the deadline
Well,
happened.
And is that both, are you saying? He completed, he did 6. No, he
And
did 5.
He was given until September 16th, 2023 to
Right.
complete the other 2 courses, but
Oh.
was terminated in July before he had a chance to complete them.
Okay, okay, thank you.
Thank you.
Any other commissioner questions for Attorney Morris? Seeing none, you'll have about 7.5 minutes left when we come back to you. Attorney Yule, do you want to reserve any of your time?
Yes, thanks. I'll reserve a couple of minutes or whatever I happen to have left. I always think I'm not going to have a lot to say, but somehow I end up talking longer than I think I do. So I'm going to first go over what we've submitted and what I think the investigator's report shows, and then I'm going to address some of these points that Sally made. What we have here is a Whistleblower Protection Act retaliation case without any whistleblower activity. The complainant was hired in June 29th, 2021, specifically on the condition, it's right in his offer letter that's in the record, that he had to complete 7 certifications and licenses to continue his employment, most of them within 12 months. He didn't do that as of 2 years later. He was hired as a code enforcement officer. At the time, the code enforcement department was part of the fire department. In 2022, the 2 departments split off, and fire department went back to town hall, as they say, and a director of code enforcement was hired. And it was explained to the complainant at that time in great detail what his position would be going forward. He's a code enforcement officer. You're there full time. You need to get authorization from us before you go out and any calls, making sure that it's really required. He didn't do that. And he had many other performance problems right from the beginning of when he was a code enforcement officer. He missed items on inspections. He issued certificates of occupancy that shouldn't have been issued. He used the wrong forms. He issued the wrong permits. He missed safety issues in his inspections, and he continued to fail to complete his courses. In April of 2023, the complainant asked for a meeting with the town manager, and very, very importantly, during that meeting, he did not in any way, shape, or form raise any safety issues or health issues. Number one, he talked to the town manager about an email he received from his boss, the director of code enforcement, saying that he needed to come back to the office in between code enforcement assignments. The director asked him one day, "What are you doing?" And he said, "Oh, I'm just out here killing time in between inspections." So the director said, "You have to come back to the office, and attend to your work here." The complainant thought that was rude. That was his complaint to the town manager. Number two, he wanted clarification as to his duties between being a code enforcement officer and being a part-time fire department personnel. That was explained to him, and as was pointed out in the questions, he was told, unless it's an all hands on deck call, you shouldn't attend. If there's a situation where you think that you're needed because someone else can't come, you just need to call the director. You need to get authorization from the director. And then his wife, who was also there, asked about him getting a raise. And the town manager said again, well, he needs to complete these courses before he gets a raise or even before he can continue to have his job. So there was no protected activity, no activity that amounted to him complaining about an unsafe or illegal condition that was created by the town. Now, in May 25, 2023, something that was not discussed in Sally's presentation was that he engaged in insubordination and unprofessional conduct when the administrator of the code enforcement office sent an instructional email out to everyone in code enforcement talking about the new way that we're going to organize and carry out permits. The complainant's response to that was, do your own job and stop telling me what to do, right? I mean, kind of rude, kind of insubordinate, kind of unprofessional. The director talked to him about that and gave him a written warning on June 21st, 2023, saying you have to stop doing that, right? This is after the April meeting. So in connection with that, the director gave him a performance improvement plan on June 21st, 2023, talking about all the things he needed to improve. His overdue certifications that he hadn't required yet, his attention to details, missed inspection items, due diligence on issuing permits. That PIP went out in June 21st. In July 2023, the complainant enrolled in a course and misrepresented to the Human Resources Director and the Director of Finance what that course was. He told them it was a Life Safety 101 course, which was one of the courses that he was supposed to complete and get the certification for that in order to meet the conditions of his employment. Instead, what he actually enrolled in was a firefighter certification course, right? And he misrepresented that to the town and incurred $700 in course materials because of that. Conveniently, the director of code enforcement was out at the time. He submitted this request while the director was out, so he couldn't kind of check on that. When the director got back, he found out that he had submitted this misrepresentation for what course he was taking. Wasn't even one of the courses he was supposed to take. It was a firefighter course. And the town and the director said, understandably, enough is enough. And in the meantime, he was still making mistakes under the PIP, right? Yeah, he didn't get to the end date of his PIP, but he wasn't showing improvement either. And in addition, this intervening issue came up in which he misrepresented what he was going to do. So the director of code enforcement gave him a letter on July 18th saying he was going to recommend termination of employment. The town manager held a predetermination hearing on July 20th, at which the complainant attended, was able to submit his side of the story. And on July 24th, the town manager issued a decision terminating employment for several reasons. Continuing deficiencies outlined in the PIP, right? He wasn't showing any improvement. He was showing that he was continuing to make the same mistakes. Just because you have a PIP doesn't mean that you have carte blanche to continue to perform poorly until the end date. Failure to follow instructions, failure to complete the required courses. Yeah, they gave him an extra time in the PIP, but this is more than 2 years later now, and he still had not completed the courses. Enrolling in the course without authorization and misrepresenting to the Human Resources Director and the Finance Director what he was going to be doing, and the unprofessional conduct dating back to that June 21st email when he said, hey, stop telling me how to do my job, worry about your own job. Whistleblower Protection Act requires, first and foremost, engagement in protected activity. There simply is no protected activity here. The complainant never went to anyone and said, hey, by me doing my full-time job, which I was hired to do, instead of going out on calls, that creates a public safety element, right? He never raised that issue. He just said he wanted to go out on calls. Town manager met with him and came up with a plan. You can go out on calls if it's an all hands on deck call, and you have to call the code enforcement officer and let him know what you're doing. He didn't do that. He continued to go out on calls without getting authorization. And this issue of improper inspections, we don't really know what that is. one of the things that he was disciplined for was that he was issuing certificates of occupancy that were unwarranted. And the director of code enforcement said, you have to stop doing this. There were no complaints that the code enforcement officer is making me issue illegal certificates or doing unlawful inspections. He never ever raised that complaint whatsoever. On the contrary, the director of code enforcement told him, you've got to do, you've got to do your job. You've got to pay attention to detail and stop issuing these permits that are unauthorized. So there was just no protected activity to begin with. Another element, of course, is there has to be a causal nexus.
Attorney Yule, I'm going to pause you for a minute. That was 8 minutes. So I've started a 2-minute timer just so you know where you're at.
Thanks very much. As I said, I just keep going and I just don't know when to stop. So I'm going to stop right there. I think I've said everything I've had to say. This is a whistleblower protection case without any whistleblower activity. Thank you very much.
Commissioner, questions for Attorney Yule? Seeing none, we'll go back to Attorney Morris. You have 7 minutes and 43 seconds if there's anything you'd like to add.
Thanks. I won't take that amount of time, but I just have one point I want to respond to, and that is that, you heard a recitation of a long history of performance problems by my client, but the only performance issues that were documented and were raised in after he complained in April of 2023. He received the written warning in June, and then they moved to discharge him in July. And so he was there for 2 years, and there were no issues until after he had the meeting with the town officials in April of 2023.
Any other commissioner questions for Attorney Morris? Commissioner Douglas?
Yeah, so maybe I've lost track of it at this point, but the meeting in April or otherwise, because, Eric says this is a whistleblower case without a whistleblower protected activity. By the way, I'm really enjoying seeing the two of you opposed. The last time I saw you two, you were working together against me, as I recall. This is really enjoyable for me. So, so I'm just wondering, I guess I want you to respond to Eric's comment that this is a whistleblower case without whistleblower protected activity. What specifically did your client raise in this April meeting or otherwise?
Yeah, I guess what I'll do is, fall back on what we alleged in the complaint. And what we alleged in the complaint specifically is that he believed he was being told he could not respond to fire calls. And he also believed that the director of code enforcement was that he had left didn't show up in an inspection and had signed off on things that my client didn't believe were safe. So that's our allegation with respect to illegal activity and unsafe activity.
All right, thanks, Sally.
Yep.
Any other commissioner questions for Attorney Morris? Seeing none. Attorney Yule, you have 1 minute and 52 seconds.
Nothing really to add. Thank you very much.
Any other commissioner questions for Attorney Yule? Seeing none, we will now move to the investigator, Carrie McCarter.
Hello again. My name is Carrie McCarter. I am the investigator assigned to this case. I don't have anything to add except that I am realizing under the recommendation on page 5, as far as the no regional grounds recommendation, that should be WPA and MHRA. I addressed the MHRA in a footnote on the first page, but it should be reflected in the findings for you to vote on as well. And I'm happy to answer any questions.
Commissioner David?
Carrie, thank you for this report. I think I have the answer in the fact that nobody mentioned on either side what I wanted to ask you about. You mentioned that there were these allegations of these minor things about losing his office or removal of a desk and the cubicle and that kind of thing. Are they just throwaways that have no legal resonance?
So I didn't see that any of that was enough to rise to the level of any type of adverse action.
Yeah. Okay. Thank you. Apparently they didn't either. I mean, they're not vigorously arguing.
Any other commissioner questions? Carrie, can you repeat what you said, something about the findings?
Yes. The finding on page 5 where the no reasonable grounds recommendation, that should be no reasonable grounds to believe that town of Old Orchard Beach retaliated against Dimitri Bauman in violation of the WPA and the MHRA.
Okay, great, thanks. Okay, so we have heard from the parties and the investigator. At this time, we're looking for a motion. There is one proposed finding. In your motion, just mention MHRA retaliation in addition to WPA, so we catch that. Commissioner Douglas?
Yeah, I'll move that we adopt the investigator's report and find that there are no reasonable grounds to believe that the town of Old Orchard Beach retaliated against complainant in violation of the WPA or in violation of the MHRA of the retaliation claim, and the complaint should be dismissed.
Second.
Moved and seconded. Any discussion?
Yeah, I don't think he was terminated. I mean, he was on a PIP, right? He was given extra time to do the certifications and so on and so forth. I think that the theft of the course, which he didn't need, I think was grounds enough to terminate him, and then have the sort of insubordinate email as well. So I don't think there's an even chance here.
Okay. Any further discussion? Seeing none, the motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien? You're muted.
I have to say, I have vertigo this morning, so I'm all over the place. Yes.
Okay. Commissioner Douglas?
Yes.
Okay. So the findings are no reasonable grounds. We thank everybody for their participation, and the commission will send a letter to the parties confirming the results of the hearing.
We take the next case?
Yes.
The next case for hearing is PA 24-245 A, B, C, and D Curtis versus Northern Lights et al. The recommendation is a split recommendation for a finding of reasonable grounds of discrimination based on disability and no reasonable grounds on retaliation. The reasonable grounds recommendation being the more significant to the further actions of the commission. I think we would hear from the complainant, from the respondent first, right?
Yep. So Attorney Sturdivant, do you want to reserve any of your 10 minutes?
I'll reserve whatever remaining time I have. Thank you very much.
Whenever you're ready, go ahead.
Fantastic. Thank you. So good morning, commissions. As was stated, I represent all 4 respondents. Just for some context and clarification, 2 respondents are entities, Northern Light Health and Northern Light Pain Clinic. The other 2 respondents are individual medical providers who are employed by Northern Light. The respondent-specific disagreement with the investigator's report is just on one recommendation of the report. That's regarding the discrimination, the finding of a recommendation that discrimination be found. Excuse me. And to be clear, this recommendation wasn't based on a factual finding, but instead was based on an inference of discrimination. And that's really the crux of our objection to this finding. So additionally, I do want to just clarify that our disagreement with the recommendation is based on as well the underlying facts of what transpired. That was submitted to all the respondent submissions to the commission earlier. We also believe there was an improper inference, and I'll expand on that one a little bit more in more detail. And then ultimately our third reason for disagreement is that even if we put aside the underlying factual dispute of what happened on January 8th, there's no basis for reasonable grounds finding of discrimination because the complainant, Mr. Curtis, did not experience any adverse action in that he actually received the medical treatment as planned. So I would suggest that even if there is an even chance that a fact finder believes that Northern Light Health staff asked improper questions of the complainant on that day, he still could not meet the requirements of discrimination. So just to kind of lay some factual context for what we're talking about, to be clear, there is an underlying disagreement on the facts of what transpired on January 8th between Mr. Curtis's interaction with Northern Light Health staff when he first presented. The issue is regarding an interaction with a service dog. Northern Light adamantly disagrees that its staff asked any improper questions. And on this point, I do just want to emphasize the investigator's report did not make any factual findings about these interactions. The only factual finding relevant and related to the January 8th interaction was that Mr. Curtis received the trigger point injections from the respondents. So again, for context, I do just want to lay out some basic facts of the respondents' position of what happened on January 8th. Mr. Curtis had a scheduled medical appointment for trigger point injections. This is a medical procedure that takes place in a sterile procedure room under live ultrasound guidance done by a physician. And at the time of this appointment, Northern Light Health had an existing service animal policy which prohibits service animals from procedure rooms and operating rooms. This was adopted to meet national and recognized guidelines regarding infectious disease controls. Given this, when the complainant showed up to the pain clinic for his appointment with his service dog, consistent with his policy, the Northern Light Health staff asked if he had someone to stay with his dog while he was undergoing these injections, because unfortunately the dog would not be allowed into the actual procedure room. This question unfortunately made the complainant very uncomfortable. Northern Light Health staff member did their best to move on, reassuring the complainant that his dog was welcome, and it shared that she loved dogs. She was looking to get her own dog certified as a service dog. Unfortunately, the complainant perceived this conversation as negative. The staff member again quickly realized that this was not going well, and that the complainant was uncomfortable, so moved forward and just brought Mr. Curtis to the procedure room with his service animal. At that point, they reviewed the pertinent medical history, which was necessary to proceed safely with the planned procedure. They figured out a plan for a Northern Light Health staff member to be with the service animal while Mr. Curtis received his treatment. The complainant moved forward with the trigger point injections, was reunited with his dog, and left as planned. The next set of facts are contained in the investigator's report, and I'm just going to highlight before I review them that these are the facts that form the basis of the inference of discrimination in this case. The following day, on January 9th, the complainant initiated a grievance with Northern Light Health about the interaction he had specific to the service animal on January 8th. Northern Light investigated, learned from its staff what happened and how the interaction went, and with this process took the opportunity to re-educate its staff about the service animal policy in general, because questions did exist. For example, what do you do if a patient does not comply with the policy by presenting with a guardian or another individual that could appropriately care for their animal? Northern Light saw this as a good opportunity to reinforce existing good policies, improve best practices and procedures to better serve both Mr. Curtis and all their other patients. Northern Light, as part of the grievance process, Northern Light shared what they did with Mr. Curtis. Mr. Curtis wasn't satisfied with the response, so Northern Light remained engaged. They met with him in person, and in preparation for this meeting, heard additional concerns from his perspective about a lack of patient education on Northern Light's policy. And again, in response to this process, again took the opportunity to ensure that the service animal flyers would be present and more visible for patients and staff, and alerted their staff to the various resources and policies for service animals. Again, all good practices in a helpful, productive response aimed at improving patient care as overall. So it's these subsequent actions that form the basis for the investigators' report to infer that its staff engaged in discriminatory conduct on January 8th. And that's really the crux of our objection to the report. Not only would these subsequent remedial actions be barred from admission by well-established evidentiary rules and case law, the policy of allowing this type of inference would undermine the goals and intent of the Maine Human Rights Act. Rather than attempt to engage with complaints in real time, respondents would be incentivized against doing so. If there's a chance that any voluntary remedial acts would be used to condemn them or to support inferences of culpability, unfortunately, the safest approach may be to not engage and not take the opportunity to improve best practices. Additionally, and again, I've laid this out in respondents' objection to the investigators' report, our position is that Mr. Curtis did not experience any adverse action necessary to establish a discrimination occurred on January 8th as well. So despite even not presenting with an individual or a guardian to care for a service animal while he underwent the medical procedure, he still received the injections. Respondents actually bent over backwards by having a staff member stay with the service animal during the injections and indeed tried to do everything they could to put him at ease. This is a pain clinic. All the staff and respondents understand that almost all their patients who present to them are in pain, need help. They choose to work there, and they truly always do their best to put their patients at ease. This was no different. Unfortunately, the interaction made Mr. Curtis uncomfortable. This was never the respondent's intent. They felt badly that he had this negative experience. They truly did their best to meet him where he was and proceed with his planned medical care. Given this, I've laid this out in our objection, providing examples of case law that support the analysis that there does indeed need to be an adverse action in order to prevail on a claim of discrimination. I'm just going to suggest both Maine case law and beyond require an actual injury more than a hassle or delay, and that doesn't exist here. I'll just briefly touch on the other points given the anticipated objection by Mr. Curtis. Respondents otherwise agree with the investigators' report and findings on all the other recommended findings. Specific to the allegations of discrimination against the individual medical providers, this was submitted, but neither providers had any interaction with Mr. Curtis and his service dog, and were unaware that there was any ongoing concerns. All the other remaining findings were based on Mr. Curtis's allegations of retaliation, that he did not receive medical care as a result of his grievances within Northern Light. We've shared this with our submissions, but the complainant had also submitted complaints against these medical providers to the Board of Licensure in Medicine, raising the
That is your time.
Oh, that went quickly. All right. Well, I'm happy to answer any questions. Thank you.
Any commissioner questions for Attorney Sturtevant? Commissioner Douglas and then Commissioner Davis.
Yes. Give me a second here. So your point about the subsequent remedial measures is well taken. You have an account in your submission, which I'm scrolling through here trying to find, where you describe the interaction about the service dog from your client's perspective. right? And your position is that, you know, the interaction, the statements made by your client are not, they do not violate the law, right? I'm gonna ask complainant this question. Has complainant definitively said, you know, what that interaction was? I mean, did he just say somebody asked me to show me his paper, show me the papers for the dog, or what is his take on this?
So I can understand your question, you're asking me to describe the complainant's position on what that interaction looked like?
What I'm asking you is, from your perspective, what's in the record in terms of, you know, you're saying that this interaction, right, there was no problem with it. There was nothing inappropriate that was said. And I'm asking you from your perspective, what is complainant's position on that?
Our understanding based on complainant's allegations, both within this proceeding, allegations before the Board of Licensure in Medicine, and his engagement with the Northern Light grievance process, is that Northern Light staff demanded that he provide certification papers for his dog. And we've adamantly denied that occurred.
Yeah. All right, thank you.
Commissioner David?
That was my question. You have a factual dispute. The investigator found that they demanded documentation, which is one of the things they can't do. They can ask whether it's a service animal, and they can ask what task it's trained to provide to the, and you deny that the finding G was that they demanded the paperwork for a service animal and the documentation, and you deny that happened, right?
We do, and just to clarify, when you reference finding G, that finding was specific to that. It did not find that was done. It was that the complainant filed a grievance asserting that there was a demand.
You're correct. That's right. That's stating that that's his position, but they do deny that they went that extra step and demanded the documentation.
Absolutely, and I shared our factual position, and just for the commissioner's reference, on page 2 of our disagreement is where I highlighted from our initial submission the narrative description of how the interaction went from Northern Light's perspective. The only question that was prompted by Mr. Curtis's presentation with his service animal was if he had another individual with whom the animal could stay during that procedure. And then the staff members reported it was clear Mr. Curtis became uncomfortable with that question, which I would pose that question was a proper, appropriate question to ask in that situation. And the staff member did her best to reassure that she loved dogs, shared she was looking into getting her own dog certified. So I think there was room for miscommunication, and very unfortunately, Mr. Curtis was upset by the interaction, and Northern Light Health's response was to engage with him in the grievance process and do their best to hear his concerns, recognize where there is room for improvement, to have flyers elsewhere for other patients. But to be clear from the very beginning and consistent, we've adamantly denied that any illegal questions were ever demanded of Mr. Curtis or asked.
That's all.
Well, you have used your time. So, Mr. Curtis, you have 10 minutes.
So, good morning. On the day of the questioning in January 2024, on the 8th, the nurse or the person that came out to get me demanded, well, first she wanted to know why I had a service dog. She demanded that I give her paperwork that showed the vaccination records, that my dog was licensed. She started asking me why I had the service dog. And then she went on further and said, well, what is your disability? And I showed her paperwork that I had that showed my disabilities by letter from my doctor prescribing the psychiatric service dog. And she, for whatever reason, she never asked me or told me anything about liking dogs or how she, what do you call it? Or how she, to get a dog certified, because there is no real certification. And so when I told her that I had PTSD and everything, she started, then when we went back, she told me that if I didn't provide the paperwork that I would not be able to see the provider that day. So once I get back there, they didn't know what to do when I was there. They didn't have no direct policies or know what to do in my situation. And they still took me back with the dog. And I was upset because this lady come out in front of everybody in the waiting room and just demanding that I show her this paperwork, asking me about my disabilities, where I was treated, medications, right in front of other people. So it was very like humiliating and stressful. And I felt embarrassed. And then when we went back, you go into a waiting area, we have all these curtains. So the lady is like saying, reading off my medication list, which is very long, and a nurse would know what medications are for. And she said, is this for your alleged PTSD? And then there was people giggling in other areas and talking about different things about me. And like, oh, she's giving it to him kind of type things. And then, so when I finally met with the lady, her name, Elizabeth Perry, and another lady, on my exhibit number 1, it said the leadership re-educated staff on policies and procedures concerning service animals. The practice has also ensured that printed patient information flyers are available and should not happen, and it should not happen again in the future. Never once have they ever denied my allegation until I filed the complaint. At no time during the grievance process did they deny my allegations of what the nurse did when I was there. They said that they were going to look into it further and take reprimand if there need be. I never found out if there was any reprimand. They told me, like in the thing, they apologized for what happened. They didn't say, well, this never happened, or we found other findings after they talked to her. And then I had other staff, two other nurses admitted, which there's documentation, which I submitted, where they specifically asked me about my service dog and why I had it and how I went about getting it and stuff like that, which was 2 separate times. One was the lady that came out and got me, which was the rude person and who was demanding paperwork and telling me I had to do this, I had to do that. And then when I got back, there was 2 other nurses that were asking me about him, and they took him, because I had him in a carrier, and they took him and put him to the side, and they did watch him while I was there, but nobody knew what the policy was. They never told me there was any policy or anything until we started litigating this. They didn't know what to do, so they did accommodate me that part. But my issue is when this lady came out demanding my paperwork and embarrassing me in front of everybody, asking me what my disabilities was, and I had to sit there and explain it in front of everybody. And then to go back and further it by going through the medication list and saying, is this for your alleged PTSD, and just like mocking me about it. And at no time have they ever denied it. That's all I have to say.
Commissioner, questions for Mr. Curtis? Commissioner Douglas and then Commissioner David.
Yeah, Mr. Curtis, good morning.
Good morning.
So I'm just looking at the investigator's report. Yeah, just a few questions there. So the report says on November 2nd, 2023, you met with a doctor for initial consultation, and then there was an appointment scheduled for trigger point injections. Do you remember when was that appointment scheduled for?
The first appointment for trigger point injections, which was the only ones that I received, was on the January 8th.
Okay, but my question is, was the January 8th meeting or appointment scheduled on November 2nd when you were there?
I don't believe I don't remember, sir.
Okay, so just so we're on the same page, right? The report says that you had this initial consultation and that you were scheduled an appointment, right?
Yes.
I'm just wondering when was that appointment scheduled?
It was sometime around that time, because I was having a problem getting scheduled.
Okay,
So it took like a couple months
okay, so
to find.
well, if I'm understanding from the report, right, it says that you had an appointment on January 8th, right?
Yes.
I guess I'm just looking to confirm or not confirm that this January 8 appointment was scheduled on November 2nd.
Yes.
Okay. Then you filed a grievance on January 2nd over the delay in scheduling your first appointment. Can you explain that to me?
So what was happening is I was waiting for the trigger point injections. My primary care office knew that I was having severe neck pain, and they wanted to get me in as soon as possible because I didn't want to take narcotic pain medication. So I kept waiting and waiting and would call, and they said that the scheduler would call me back, and I wasn't getting anywhere. And finally, I talked to, I believe it was an office manager, and they said that someone would call me back. And after that time, I was told that you could go to patient experience, and I filed a grievance with them saying, hey, I can't get in, and what was going on.
Okay, I'm sorry. And that grievance that you just referenced, when was that filed?
That one was filed
January 2nd?
No, January, but yeah. It was responded to January 17th. It was after my appointment. This grievance was filed after my January 8th appointment.
Okay, well, my understanding is you filed a grievance after your January 8th appointment arising out of the service dog issue, which is why we're here today.
Right.
Is that correct?
Right. Yes.
All right. And I've not seen your patient grievance that was filed on January 9. Are you telling us that, basically what's in that grievance in terms of the interaction and the questions that were asked about your documentation matches what you told us today?
Yes, on the exhibit that I put as Exhibit 1 with my complaint, and it's dated January 17th, that's where I talk about what happened during the January 8th visit.
Okay. And then I see you filed another grievance on April 3rd, 2024. Tell me about that one.
What happened is after the service dog incident on January 8th, I continued to try to get in for more injections, and I was told that I was going to receive a series of injections, and if that didn't work, they was going to do something where they kill the nerve called an ovulation. I believe that's what it's called. Well, after that incident, I did not get to see another provider until I seen Alan Coleman. And then Alan Coleman said that they had decided, after reviewing everything, that I was a conflict of interest because I had filed a complaint against Dr. I can't say her name.
Yes.
Husband, Ibrahim, that it was a conflict of interest and that they decided not to treat me no more. And then the next time I seen them, it was through a grievance, and they had me set up with Dr. Mahmood. Dr. Mahmood said that I had myofascial.
Yeah.
Please don't use that person's name. They're not a
Oh,
party.
I'm sorry.
That's all right.
Another doctor told me that he diagnosed me and started setting up a plan to do other things. So the issue was with the other grievances was not so much after the January 8th one, was not about the service dog. It was about staff not wanting to treat me because I had filed that grievance and dealing with a service dog because they did not know what to do if I was to bring the service dog with me. And then the final one with the final doctor, I didn't bring the dog with me or the one with the other provider.
Okay. And that's on April 22nd, right?
I believe that's the date. I don't have the date in front of me.
Okay. And then at that appointment, I'm told that you were informed that the physician assistant that treated you did not recommend any more trigger point injections.
Correct.
Okay. And then you filed another grievance after that.
Correct.
Okay. And you claimed patient abandonment, right?
Correct.
that wasn't your last appointment. You had another appointment in July, true?
Correct.
Okay. All right. All right, thank you.
Any other, Commissioner David, did you have a question for the complainant?
Yeah, Mr. Curtis, you agree that after the discussion about the service animal, that the provider conducted that training and reviewed the correct things that employees could do and couldn't do about a service animal?
I don't know who initiated it. There was, when I got Discovery, they had said that they had educated them, and in the grievance response, which was the exhibit 1, it said that they re-educated staff about how to deal with the service animals and what to do in certain situations.
My question, sir, is that after that and going over that incident, your allegation is that these delays in treatment and abandonment of you by the physician is all in retaliation for that mistake, if it was a mistake? I mean, they deny that exactly what happened about the
Right.
service animal, and that went on
Right.
for months with different providers and different appointments. It's all
Right.
retaliation. Is there any
Because,
direct evidence of that?
here's what I believe is the evidence. When I first started the trigger point injection, she had set up a plan that said that I would receive a series of injections, and if that did not work, then it would be an obligate where they kill the nerve.
Yeah. But are you saying that because of the controversy about the service animal, they changed that that it's the service animal issue that causes them to change that plan, that they don't follow through, that they say you're?
Yes, I believe that is exactly what happened.
And that requires, does it not, the participation of a number of providers and people all agreeing that we're not going to treat this guy anymore because he brought a service animal and says that we improperly inquired about it? It just sounds like it's too much.
Well, I can't say the name, but the last meeting that I had, there was an apology and more recommendations to go to another clinic in Boston and for other medical devices to be used. So
You don't think that that's based on your response to their survey and you said it was only 40% effective, so it's not doing the job. So they're trying to deal with your particular situation and whether it's working or not.
I don't feel that they gave it enough time to test to see if it worked or not, because not just one set of injections is enough to make a decision.
Well, I hear you saying that you don't believe that they gave it enough time, but that's a medical question. You're not saying that they didn't give it enough time because you complained about a service animal back in November, right?
Right. Yeah, I'm saying that I believe that they stopped treating me once I had made the complaint about the service animal.
Got it. Thank you.
Any other commissioner questions for Mr. Curtis? Seeing none, we've heard from both parties, and next we'll hear from Alex Brindley, the investigator assigned to this case.
Morning, everyone. I'm Alex Brindley. I conducted the investigation in this matter. Just one thing that Commissioner Douglas, you asked about the complainant in regards to the November 2nd meeting. I believe there was in fact a delay in scheduling the appointment. I think there was something to do with the insurance. On November 2nd, the doctor had put in basically in his record saying that he needs to have an appointment to do the trigger point injections, but I believe it was delayed by insurance. So I don't know the exact date in which that appointment was scheduled. So there was that delay there. But to get to the main points, let me pull up my notes. In regards to the claim of disability discrimination, as the commissioners know, this is not a court of law. So we are not constrained by the rules of evidence as described by the respondent counsel here today. Given that and the fact that this is a preliminary investigation, I determined that based on the evidence that was provided to me, specifically the email sent to staff immediately after the complainant's appointment on which is found on page 3, stating staff cannot ask questions about the service animals. We're not allowed to ask if an animal is brought in as a service animal or for service dog paperwork. The animal must be on a leash, etc. That and the statements provided from the staff members itself to respondent found on the following page, wherein the supervisor provided the following statements for respondent's investigation. After researching who was working with this patient, I had 2 staff members meet with me. I asked both staff members what happened. They talked about how they asked questions about their service dog out of curiosity. So based on those 2 things in particular, I determined that there was at least an even chance that the respondent had in fact asked unlawful questions regarding the complainant's service animal. And that in itself is the adverse action. That's it, is the unlawful questions or inquiries about the service animal. In regards to the claim of retaliation, there was no evidence in the record that the respondent denied complainant medical care. He continued to receive medical care despite making complaints against respondent staff. It might not have been the treatment that he wanted and specifically requested, but all medical professionals provided that the trigger point injections were not the appropriate treatment for complainant. And as stated in my report, the commission does not have the jurisdiction to determine the appropriateness of medical care, only whether or not discrimination occurred. So that's it. Are there any questions?
With respect to the November 2nd meeting,
sure.
Right? So you're telling me there was a delay. That's great to know. Do your notes indicate when the January 8th appointment was actually scheduled?
From what I can remember, I believe it was scheduled after he made his complaint on January 2nd.
And I want to be careful here. What I thought I just heard you say was that what happened after the dog encounter, right? In terms of the instructions that they gave their staff and so on and so forth. You found that to be persuasive in terms of raising this to an even chance case.
Absolutely.
Do I understand that? Okay. Without that, is it a tougher case for you? I mean, does the evidence
certainly
sort of point to this was said, these inappropriate statements were said, they were not said?
Absolutely. I mean, the parties blatantly disagree on the facts of the case here. Based on what was provided to me, I found it very, I mean, if I didn't have those facts, would be an entirely different case. So yes.
All right, thank you.
Any other commissioner questions? Yeah, Commissioner David?
Yeah, I had a little trouble hearing Commissioner Douglas. Was he asking you what the effect was of their, I say admission, the fact that they went ahead and retrained the staff and said you can't do that and reviewed the rules and that kind of thing? What effect does that influence your conclusion about the rest of it? That his allegation is that they're retaliating?
So to me, it was less about how the respondent engaged in these remedial actions and more about their direct response to the incident itself. So the email that was sent directly to staff after the January 8th incident, and then the statements by the staff members to their supervisor about what happened. That was really most telling to me about the claim of discrimination. Could you repeat your question about the retaliation?
The fact that they took corrective action about and retrained the staff about what they could do in terms of asking about a service animal or not, is the fact that they undertook that affect your conclusion later on in the months that follow in the winter and spring that they're retaliating against him?
No, I find them to be entirely different analyses.
Okay.
Any other commissioner questions for the investigator? Thank you, Alex. Where am I? All right, we have heard from the parties and the investigator. This time we're looking for a motion, or if you want to take these separately, motions. There are 5 proposed findings.
My proposal is to take them together. Is there any objection from my commissioners about doing that?
Depends on what you're gonna say.
Oh, you want to hear what the motion is first? The motion is to follow the recommendation and find that there's no reasonable grounds, that there are reasonable grounds that the discrimination occurred on the basis of disability, and that there are no reasonable grounds on all of the 4 remaining retaliation accounts, and that those should be dismissed.
So just to be clear, the first recommended finding is to believe that Northern Light Health and Northern Light Interventional Pain Management Clinic discriminated against Mr. Curtis on the basis of disability. The second recommended finding is no reasonable grounds to believe that either of the individually named respondents discriminated against him on the basis of disability. And then the last 2 are the retaliation.
Yes.
Okay. For the last 3. I can do math today. So move to adopt the findings as presented in the report. Do I have a second? This is going to be interesting.
You want to take them separately, Tom?
Yeah. Let's-
Okay.
I think Julie's still thinking, so. No, she's not. Okay. All right. Should we entertain a different motion?
Yes, I think that, yes.
I would move that let's start by taking recommendations 2 through 5 together and adopting those recommendations as stated in the report.
Second.
Okay. Moved and seconded. Any discussion on the motion regarding findings 2 through 5? Okay. Seeing none, that motion is to find no reasonable grounds on all 4 of those recommended findings. If you were in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Okay. Next.
Bated breath.
I think I'm gonna move that there's no reasonable grounds to believe that the respondents discriminated against the complainant on the basis of disability, and the claim should be dismissed.
Julie's trying to second that. You're on mute, Julie.
You're right.
Second.
Moved and seconded. Any discussion?
Yeah, I mean, I think that this is, first of all, that I think that Respondents Council makes a really good point about the subsequent remedial measures, and the important point there is that we are trying to figure out how this case is going to come out at trial. To the extent that some of these things are characterized as subsequent remedial measures, they are not coming in at trial. I think Respondents Council is right about that. And we heard the investigator say that without that, it's a much harder case. I think the other thing that gives me pause here, and this is, I don't know what happened. What I do see is a very detailed account of what occurred with respect to the service animal during this January appointment. I'm not sure what happened. And then I just have to be honest, I'm troubled by all these grievances. And I did hear from the investigator, at least one of these grievances was substantiated, but I'm troubled by that. And so I just think, all things considered, I don't see that there's an even chance that complainant is going to prevail.
Can I ask you, Tom, you don't think there's an even chance that he prevailed, that they crossed the line and asked the improper questions about the dog? I mean, that just seemed to me that was sort of open and shut. I'm troubled by the fact that I'm saying, well, what would be the remedy for that? It would be to train the staff, educate them. You can't do that, and they already did that. But it seems as though that there was that he certainly got an even chance of persuading a jury that they asked him for the documentation, and that's what you can't do.
Well, it's gonna be he said, she said, respectfully.
Okay.
Not gonna be all this stuff about what they did after, arguably, depending on your judge and how it's presented, that's not coming in. The jury's not gonna hear that, so.
And you're also pointing out that all the 2 through 5 and all of that complaint against retaliation is sort of influencing you in terms of whether there's a what, a good faith belief that they made improper inquiries?
I
You're
just don't
saying,
think-
yeah.
And I just don't think that there's any retaliation here. What I think is that.
I don't either. We voted for that.
Right, and I think, yeah, right, and I think that it's a busy clinic. What we heard from the investigator was there was a problem with insurance at the beginning, and so there was a delay in getting this man scheduled, right?
Yeah.
And then he filed a grievance, which apparently there was some substance to that, and they got him scheduled right away. So it just seems to me, maybe we just have an overburdened respondent rather than an abandonment of care. And then he did go and get this last procedure done in April. They say, well, it's not appropriate for you to have any more procedures done, any of these injections done. And he filed another grievance, right? And then I guess there's a meeting after that where that decision is sort of backed up by another medical provider. So
I agree with all of those things, that there's no retaliation, that's just a busy clinic, and maybe a change in diagnosis or treatment after getting further information for him about what's working or not working. But how does that affect whether or not they made the wrong demand about the service animal?
well, I just
got it.
Yeah, I just think there are a lot of grievances here.
Yeah, I hear you.
I'm troubled by it, and if I'm on the jury, I'm troubled by it. So
I hear you. I'm torn about it. Yeah.
Any further discussion? Yes.
Julie?
Yeah, go ahead, Julie.
Okay. I agree with Tom, and I agree about the grievance issue, several grievances, and it was a very detailed and drawn out explanation by Mr. Curtis about what happened at the meeting about the I apologize, I cannot speak today. It was drawn out, and I didn't see that, all of that in any of the reports. And well, I'll just say that who's right, who's giving the accurate description. Leave it at that.
So the motion is to find no reasonable grounds on finding number 1. If you are in agreement, you will vote yes. Commissioner David?
No.
Commissioner O'Brien? Julie, you're muted again.
I know. I know that. I apologize.
That's all right.
Yes.
Okay. Commissioner Douglas?
Yes.
Okay. So the findings are no reasonable grounds on all counts. The commission will send a letter to the parties and the council confirming the results of the hearing. We thank you all for being here today. Take a break. I need your lunch order. Also, I sent you the Whippers menu.
How much time you guys need?
Let's say 5 minutes. Okay, 5 minutes.
5 minutes. Thank you. we set? Ready, Kit? What's that, Kit?
All right, now you're.
Yes?
Yep.
Okay, the next case is Sarah, PA 248 A, B, and C, Sarah Chagon versus York Judicial Center. The recommendation is for finding of no reasonable grounds. We'll hear from first for presentation from complainant.
Is there anyone here for the complainant? Sarah, Jeremy, do you know how to pronounce her last name?
I've been saying Chanyon.
Okay, that's what I would have guessed, but given how we pronounce French words in Maine, I wasn't sure. Is there anybody here for Sarah Chanyon or Chagnon or Chagnon, if we're being fancy? I have not seen her on Zoom.
Well, I'll move acceptance of the investigator's report.
So, okay. Was that your motion, Ed?
Yes.
Okay.
Second.
So moved and seconded. This is right. One proposed finding, no reasonable grounds. Okay.
Yep.
Any discussion? Okay. Seeing none, the motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Okay. So the findings are no reasonable grounds. Thank you for coming down.
It's the easiest job I've ever had.
The commission will send a letter to the parties confirming the results of the hearing.
Next case is E240261 Vanessa Morton versus Hope Association. The recommendation is for a finding of no reasonable grounds. I think it's on one count. And we'll hear from complainant first.
Ms. Morton, you have 10 minutes. Do you want to save any of that time to respond?
If any is left.
Okay, whenever you're ready, go ahead.
Hi, my name is Vanessa Morton. I am representing myself in my complaint against Hope Association. During my time at Hope Association as training coordinator, my responsibilities extended throughout Hope Association. I trained new employees, collaborated with human resources, quality assurance, leadership, and staff across multiple programs. I disagree with the investigator's recommendation because it resolves numerous disputed facts in respondents' favor despite contemporaneous evidence creating genuine factual disputes on whether my discharge was for misconduct. The record demonstrates that respondents' explanation evolved over time, making those credibility determinations especially inappropriate at the investigative stage. This case relies on disability disclosures, accommodation requests, and contemporaneous communications that were recharacterized to appear as misconduct and compiled into a disputed record of coaching without those disputes being tested against the record. The record raises a factual question as to whether disability-related communications were later, oh, I'm so nervous, were later reframed as misconduct. I need a second, I'm sorry. One of the many examples of recharacterization within the record is as follows. My former supervisor acknowledged in writing that I did not have a fixed daily schedule because of the nature of my role, which was a newly created position. And she instructed me to work 30 hours for which I had been hired while approving additional flexibility in my schedule. My objective time cards demonstrate that I consistently met those required hours and did not have an attendance problem. Respondent continues to deny these communications. I ask that you recognize that the record demonstrates that the sustained narrative portraying me as an employee with long-standing attendance, conduct, and performance problems comes overwhelmingly from a single individual. My 90-day performance review, written by the same individual, describes an employee making valuable contributions, expanding the training coordinator position, and pursuing additional certifications. This review was signed and acknowledged by me while the supposed record of coaching was not. Furthermore, human resources, quality assurance, and the residential director, all individuals who worked closely with me, did not describe me as an employee with longstanding conduct or performance problems. The former executive director, who was my former supervisor, is the same individual who received my disability disclosure, remained central to the accommodation process, and created the disciplinary narrative, which ultimately became the primary source of the respondent's explanation for my termination. The contemporaneous record reflects a clear degradation of the accommodation process. On April 4th, the human resources accommodation process was interrupted when my supervisor canceled further human resources involvement after independently approving my accommodations and confirming that we mutually understood them. She stated, "Just one extra day, as it would be tough to say that you can and not others." On May 7th, accommodations that had already been approved were denied, and I was accused of just wanting to take the rest of the day off. My supervisor later reconfirmed those accommodations and apologized. On May 13th, my supervisor announced her resignation from executive director. The following day, I requested another human resources meeting. On May 15th, human resources submitted a grievance against my former supervisor. On Friday, May 17th, Human Resources was terminated just hours before my second planned accommodation meeting. My former direct supervisor immediately assumed the role of HR and held the meeting. My accommodations were retroactively given contingency for the first time during this meeting, but I did not question this due to the absence of HR. Then on Monday, May 20th, I received an early morning email letting me know I would no longer be allowed to paint in my office after hours and that I had a pending disciplinary action. The disciplinary characterized approved flexibility as misconduct, cited dates for which I had explicit permission, and postponed accommodations that had already been approved in writing. When I stated that I intended to review the emails, text messages, and other records before responding to those allegations, my employment ended immediately. Initially, I thought slamming my office door after having my accommodations removed was why I was fired. The timing and the record do not uphold that reasoning because I was fired immediately after saying I would review the communications for the rebuttal. Commissioners, a great deal changed between Friday and Monday. On Friday, permission was given for me to go home while my former supervisor terminated HR in the next room over, and I was told my accommodations would continue during the meeting later that day. But by Monday, many of those same interactions had been reframed as misconduct, supporting discipline, and ultimately termination. Throughout this record, the same events appear twice, once in contemporaneous communications and again in respondents' later summaries. Those later summaries repeatedly transform approved flexibility, disability disclosures, and ordinary workplace communications into evidence of misconduct. May 17th is just one example where I was given permission to work at home, and my former supervisor explicitly stated in Vanessa Convos that she said it was okay because she was busy, and that she gave me permission to prevent addressing the issue in the moment. That abrupt shift is one of the factual disputes that I'm asking the commission to allow to be explored at a hearing. It is also a prime example of a lack of direct communication that Hope Association claims to honor. The shifting explanations did not end with my termination. During the Department of Labor proceedings, respondents' explanation continued to evolve. Under oath, my former supervisor acknowledged that materials were gathered for my personnel file after my employment ended, and her account of me abandoning my workplace on January 22nd changed when confronted with objective time card records. I respectfully ask you to weigh those evolving explanations against the contemporaneous record. I also asked the commission to closely compare respondents' principal documents, Vanessa Convos, and the written disciplinary action with the original emails, text messages, human resource records, time cards, and my performance evaluation. Those contemporaneous records create genuine factual disputes that cannot be resolved simply by accepting respondents' later summaries. The contemporaneous records also conflict with the statement written on the disciplinary document that I continued to abuse the term accommodations and came and went as I pleased. If the commission considers respondents' characterization of professional boundaries, I also ask that it consider the contemporaneous context of that relationship. The record contains repeated communications demonstrating that our working relationship was mutual and frequently encouraged by my former supervisor, who held all of the organizational authority. She invited me to her father's celebration of life, told me that she loved me both in person and by text, invited our children to spend time together outside of work, and repeatedly discussed her own use of Paxil while encouraging me to consider medications for the symptoms I had disclosed. The record also contains my message explaining that I felt wildly uncomfortable after learning that my private health information had been shared without my consent. Those contemporaneous communications provide important context that is difficult to reconcile with the respondent's later characterization of my conduct. Much of respondents' narrative depends on treating evidence of disability as evidence of misconduct. My accommodation requests and uses became attendance problems. My professional discussions became coaching. My self-awareness became instability. The same facts were repeatedly recharacterized to support discipline. I am asking the commission to recognize that the record contains genuine factual disputes that should be resolved through the hearing process and not by accepting one party's later characterization over another's contemporaneous evidence. For those reasons, I respectfully ask you to reject the investigator's recommendation and find reasonable grounds. And thank you for your time. Thank you.
We don't have Kleenex.
Sorry, I'm just so nervous. I'm so sorry.
It's fine. Lots of people are nervous when they come here. And you do usually have Kleenex, but I apparently left them downstairs today. I'm gonna ask if there are any questions for you. Do you want to take a minute?
No, it's okay. It's okay. I'll cry either way.
Fine. I'm a crier myself. I get it. Commissioner questions for Ms. Morton. Commissioner O'Brien.
I don't have any questions right now, but I want to thank you for presenting. I know it's not easy.
Thanks.
Any questions for Ms. Morton? Commissioner David?
Ms. Morton, the investigator says that you never asked specifically for an accommodation because of your disability, nor provide any documentation of that disability. How do you respond to that?
So my former supervisor submitted part of an email thread, and I believe that that was taken in whole. I submitted the entire email thread that shows further down in the conversation. She solely approved those accommodations for use. And what was the second part? I'm sorry.
Well, the question is whether you said that what you were asking for was related, what you were asking for in terms of your schedule and working from home and that kind of thing, that was related to, that was an accommodation because of a disability. Did you specifically say that? Did you say that?
Absolutely, I did. And it was through HR and my supervisor, but she removed HR from the process twice.
I'm not sure I understand removed HR from the process.
Okay, so the email thread ended on April 4th with her approving the accommodations. And she stated that we didn't need to meet because we mutually understood what was being said about the accommodations. And then in May, she submitted her resignation, and I asked for another meeting with HR because I knew that my accommodations were only through her at that time, and I wanted them in my file before she left the organization. But
Okay.
the day that meeting was supposed to happen, she fired HR and she had the meeting.
She fired the person that was the HR.
Correct.
In the HR position. Okay.
Any other commissioner questions for Ms. Morton? Seeing that, you have about a minute and 20 seconds left. Attorney Haley? Yes.
Thank you. Before we begin, I just wanted to introduce my colleagues, our summer associates this summer. This is Kelsey Dykes and Helena Clark, who are both interested in employment law, and hopefully they'll be appearing before the commission on behalf of Credit Clarity in the years to come. So, thank you for being here.
Do you want to reserve any of your time?
No.
Whenever you're ready, go ahead.
Ms. Morton, I also want to recognize that this is a difficult process, and I thank you for your time and for your bravery. This is a difficult process. The Hope Association is a disability services and support organization, and the Hope Association hired a complainant, as she said, as a training coordinator in December 2023, which was a new role. The complainant was scheduled to work one scheduled day from home per week. And over the course of her employment, complainant did receive coaching on professionalism in the workplace. She left work without permission on several occasions, and she also admittedly struggled to maintain appropriate boundaries. In March 2024, she did mention to the executive director that she struggled with mental health. The executive director suggested that she explore accommodations and what potential accommodations may look like with human resources. The executive director suggested that accommodations could potentially include working from home an additional scheduled day, coming in a little later, moving to an office with more light. But complainant did not think that she'd be able to schedule an additional day out of the office and declined to meet with human resources. In the meantime, complainant continued to have some attendance issues, leaving work abruptly without permission, working from home without approving the schedule in advance. And then finally on May 14th, Ms. Morton did email human resources and asked to discuss accommodations. On May 17th, there was a meeting in which potential accommodations, including 2 additional scheduled work from home days, were discussed. But the executive director specifically said that in order to approve those as formal accommodations, that she would need to update the telecommuting policy, which would need to ultimately be approved by the board of directors. And so that was a May 17th meeting. There was a meeting scheduled on May 20th just to discuss expectations moving forward and some issues with leaving work without permission and how that was going to work moving forward. In that meeting, unfortunately, Ms. Morton used profanity. She slammed the door. She barged back in. She took papers from the executive director's hands. She raised her voice. She threw papers and files around in her own office. And in Ms. Morton's own words, contemporaneous, the next day or the next few days in an email to Hope Association, she wrote, quote, "I understand my behavior during the disciplinary was probably the actual reason I got fired." On her Facebook page, she wrote, "Drawers were aggressively opened and closed. I know that I came across aggressive that day. I am not innocent in my behavior on 5/20. She also wrote that she raised her voice and slammed the office door, and she did slam the door like she meant it. During the Issues and Resolutions Conference, she mentioned that she suspected that slamming the door, quote unquote, did her in." In her disagreement with the investigator's finding, she wrote that she has consistently acknowledged that she slammed her office door and raised her voice. She takes responsibility for her emotional reaction. In her charge, she writes, "Raising her voice and slamming office door broke the code of conduct policy and mutual respect policy and was not in the best interest of the employer." So while there were, the interactive process of discussing potential accommodations and formal accommodations was happening, there was an intervening event. And it was that meeting with her on March 20th in which Ms. Morton behaved inappropriately and unprofessionally. And that was the sole reason for her termination.
Commissioner, questions for Attorney Haley? Mr. Becker?
Yeah, good morning, folks.
Good morning.
Good afternoon. So this meeting on May 20, I'm just looking at the investigator's report. I just want to understand, because at some point it's basically stated that she needs to behave professionally and all these sort of things. And we're gonna sort of table your request for accommodations until July 19, right? And then if everything's cool as of July 19, we're gonna revisit this, right? is that before or after sort of we get emotional during the meeting? Like,
Let's say that again.
okay, so
Sure.
this is, maybe I'm mistaken. This is the same meeting, right? So there's a meeting where the complainant gets very emotional, slams the door, comes back in, grabs the paper, all that.
Right.
That's this May 20 meeting, correct?
Yes.
Okay, so this discussion about let's table your request for accommodation till July 19th. My understanding would be that that happened before the emotional outburst.
It did not.
Okay.
So what my understanding is that the executive director emailed Ms. Morton and let her know that she wanted to meet with her on May 20th. And Ms. Morton followed that up with 3 phone calls while the executive director was on the phone or in other meetings. And so interrupted her repeatedly, wanting to know what the meeting was about. And so it was communicated that the meeting was about discussing like performance and expectations moving forward. Ms. Morton walked into that meeting defensive, said, just give it to me, and took the paper from the executive director's hands. The executive director asked to go through the content of that document, and things escalated, but Ms. Morton walked into that meeting defensive and behaving aggressively.
Okay, so then after the outburst, right, then now we're having this conversation about we're going to just table all this until July. The implication being we need to see how things go.
I don't know if that was the implication. It was more just, we've discussed these. Ms. Morton already had some flexibility in her schedule as it was, but it was just the expectation that you can't come and go as you please and things need to be approved in advance, and nothing had changed from prior discussions. But I do know what you're referencing from that document. I don't think it was that there would be no discussions about accommodations, but that it was an expectation that we want to see that you follow the call out procedures, and if you need to work from home an additional day, that's scheduled in advance.
Okay, so that's the reason why we're not gonna make a decision on the accommodations now, May, we're gonna wait till July.
It also needed to be approved, the telecommuting policy needed to be updated. And so I don't know if it was somehow tied to a board meeting, but that's just speculation on my part.
You were gonna update the policy.
Yes. Which needed to be approved by the board.
All right, okay, thank you.
Commissioner David?
So the paper that she took from the director was reciting those things, that we're going to consider these and update the policy, and you need to behave professionally. And she came in with a chip on her shoulder and reacted badly to the whole thing.
Yes. Yes.
You're saying that but for the behavior that was the cause of terminating. It's
Absolutely.
not a question of not knowing that has a disability and need to be in the interactive process.
Absolutely. Commissioner Davis, in fact, on May 17th, during that meeting about potential accommodations, Ms. Morton asked whether she was going to be fired, and the executive director said no. And so that meeting on May 20th was about expectations moving forward and performance. And it was solely because of Ms. Morton's behavior during that May 20th meeting, which she has, in her own words, several times admitted was unprofessional, aggressive, was the sole reason for her termination.
Okay, thank you.
Thank you.
Just to state the obvious implication here, right? Even if you had granted this accommodation, right, given her 2 days, the obvious implication from your client's perspective is that she would still not have been able to sort of appear on the job and perform satisfactorily. Is that fair?
Well, that her behavior violated the code of conduct, and that was the reason for her termination.
But that would not have been altered by granting the accommodation. I think
that would not have had an effect on the accommodations, correct?
Okay, thank you.
Any other commissioner questions for Attorney Haley? 6 minutes left. Ms. Morton, you have 1 minute and 19 seconds.
I have the disciplinary here, and it was already decided before the meeting. If expectations are met by July 19th, these additional accommodations will be reviewed again. So that was determined before we went into the meeting. The reason I went in there with a supposed chip on my shoulder is because I was told all the way back in April that my accommodations were already active. And then the disciplinary record went through, and specific dates where I was actually given permission to go home are listed here as like an offense. As for asking whether I would be fired, that was simply anxiety because HR had been terminated that morning. I mean, I think that's a very valid question. I was involved with the HR situation to the extent that I knew about the grievance that she had filed against my supervisor 2 days prior, and I had been privy to reading it and going through it. But the only reaction during this meeting that was before I was terminated was slamming the door and raising my voice from the hallway because my supervisor was speaking from her desk in her office while I was at the photocopier. I did slam the door. I thought it was ridiculous that accommodations were being discussed on Friday and then taken away on Monday with nothing in between. And on Friday, that was the first time.
That's your time.
Oh, I was going to say that was the first time that the accommodations were given contingency was Friday.
Any commissioner questions for Ms. Morton?
I just want to note that first I want to echo my colleagues and say, we understand this is a difficult thing and think you're doing, I'm sorry. And you've probably noticed a slight smile on my face. I'm enjoying the fact that you were very nervous the first time you got up. Now you seem very calm, cool, and collected.
There was some not so true things said, so.
That was quite the savvy rebuttal, so thank you for that.
Commissioner O'Brien?
Thank you. I'd like to get your comments on looking at the investigator's report that talks about this door slamming incident. And the finance director said, I got up and mentioned to the director she needed to be watched and escorted out of after getting her personal items. Her attitude was horrible. She emptied her personal file cabinet by throwing the files all over the floor, slamming things around in a violent manner. I honestly thought she was going to throw the cabinet. The scenario was quite scary. Can you speak to that, please?
Yeah, so I would say that's pretty dramatized. The filing cabinet was a gift from my husband. I would not throw that. It's gone with me through 3 different jobs. As for her saying that I needed to be walked out of the building, after that meeting was held and I went back to the office, to my office specifically, I was trying to pack up my things. And the file cabinet that I'm referencing was my personal file cabinet, so I intended to take that with me. And I took the entire stack out of it and set it on a desk. And because the stack was so tall, it fell onto the floor, and that started the characterization that I threw files all over the floor, when the reality is it was just an entire drawer full that I had set down on their desk.
When is it that you're told that you're discharged?
So I was told that I was discharged immediately after I said the words. I was going to review all of our texts and calls to respond to the disciplinary. And it was not after I slammed the door, because after I slammed the door is when I went back to her office and I got the disciplinary to make photocopies. And while I was making those photocopies, she was communicating with me from her office, telling me that she would selectively remove certain things from the disciplinary. And I told her I didn't want her to. I was going to go through every single communication we had ever had, and I was going to go back through that and submit that as a rebuttal. And she said, that's it. I'm sick of how you act. You're fired.
Okay. Thank you.
Questions for Ms. Morton? Attorney Haley, you have 6 minutes and 6 seconds. So just quickly, Ms. Morton was given an opportunity to respond, and during that May 20th meeting, it was discussed that one of the points on that disciplinary was that she had reached out to a manager while she was on vacation. And during the meeting, it was discussed that the manager had welcomed that communication, even though she was on vacation. So you could see that that was crossed off. Ms. Morton was terminated
after the discussion with the profanity. She was asked to lower her voice because there was a meeting in the next room. She would not. And in Ms. Morton's own Facebook post, she recognizes that the witness is a person I have absolutely no issue with and never had an issue with. I would have expected a little less bias from her, so that part does confuse me. So the witness who submitted a sworn statement about her behavior had no skin in the game. And Ms. Morton has recognized that as publicly as her Facebook posts. And so that is a reliable interpretation of the sequence of events. And she was only terminated after her slamming the door, profanity, not correcting her behavior after asked to stop using profanity and to lower her voice.
Commissioner David?
Might one argue that the volatility is part of the disability, is part of the problem?
No, it's well settled law that, violation of code of conduct and policy is not excused by any sort of disability. But even then, Ms. Morton has never provided medical support for any disability or accommodation request.
Okay, that's a helpful response. Thank you.
Any other commissioner questions for Attorney Haley? Thank you. Next, we will hear from Angela Morse, the investigator assigned to this case.
Hello, I'm Angela Morse. I'm the investigator that was assigned to this case. Based on my preliminary investigation, I recommend a finding that there are no reasonable grounds to believe that Hope Association discriminated against Ms. Morton on the basis of disability in violation of the MHRA. I don't have anything to add at this point, but I welcome any questions.
More questions for the investigator? Commissioner David?
Angela, do you agree? Do you agree with respondent's statement that it's totally the behavior constituting a violation of the code of conduct that is the reason for her termination?
I do.
Yeah,
I do, and I think the complainant was pretty forthcoming about how the behavior was not appropriate, and the testimony that the behavior was scary. I thought that was credible as well.
Okay, it's tragic, but I got it.
Any other commissioner questions for the investigator? Seeing none, thank you, Angela. We've heard from the parties and the investigator. At this time, we are looking for a motion. There's one proposed finding.
I'll move that we find there are no reasonable grounds that respondent discriminated on the basis of disability, and the complaint should be dismissed.
Okay, you got to say it out loud, Julie, so I can hear you.
I reluctantly second that.
Okay.
And I reluctantly make the motion, Julia. It is unfortunate, but the organization itself is a provider of disability services. I don't think that they're jerking her around or finding a pretext here with that behavior. So I understand your reluctance to second it, but I don't find discriminatory animus.
Right. Moved and seconded.
Tom?
You really want me to weigh in?
Yeah.
I mean, I got my lunch in front of me, man.
I want you to change my mind if that's what you want to do. No, okay.
I guess that, look, since you asked, I think that, this is an unfortunate employment situation, but
yeah.
Main law is that, this is an at-will state. Folks can be fired for any reason or no reason at all, as long as it's not discriminatory or otherwise unlawful. I just don't see any unlawful conduct here, fortunately.
Yeah, thank you.
Any further discussion? Seeing none, the motion is to find no reasonable grounds. If you're in agreement, you will vote yes. Commissioner David,
Yes.
Commissioner O'Brien,
Yes.
Commissioner Douglas.
Yes.
Findings are no reasonable grounds. The commission will send a letter to the parties and council confirming the results of the hearing.
Next case is E240268, Zeldar versus Excella Consulting. The recommendation is for no reasonable grounds on both alleged counts of discrimination, and therefore we would hear from complainant.
1 minute while we get you pinned, Mr. Zedler. There we go. Okay. Mr. Zedler, you have 10 minutes. Do you want to reserve any of that time?
Yes, if there's any.
Okay.
Good afternoon, commissioners. My name is Nick Zedlar. I'll reserve any remaining time, as I said. Today, I'm asking the commission to reject the no reasonable grounds recommendation due to multiple errors, omissions, and misreadings. For example, the report treats Excella's unsubstantiated claims as facts. It accepts labels like performance, transfer, conduct, and threat without requiring contemporaneous records to back them up. The report also gets critical dates wrong by a whole year. That matters because the case depends on sequence. Retaliation is often shown by timing, what happened after protected activity, how quickly it happened, and how the employer's story changed. If the timing is wrong, the whole chain of events is distorted. The core question is, if Excella's reasons were real, documented, and neutral, where are the records? I asked for them. My lawyer asked for them twice. As a result, there is no record and evidence of contemporaneous documents saying that the client wanted me removed, that there were serious performance problems, or that a credible threat assessment was made. And that absence matters. The sparse record that Excella did produce was not of a normal performance management file. It is a suspiciously redacted smattering of private messages about me, not to me, which I was not aware of at the time. The problem is that the report treats this back channel criticism as if it were feedback and a legitimate supervisory coaching record. It is neither. This is not a new or unusual point. The Commission's own published reports have treated missing documentation, close timing, shifting explanations, and after-the-fact performance claims as reasons to test an employer's story, not to simply accept it. I am asking for the same common sense treatment here. Yes, it is the job of a supervisor to supervise, but supervision means direction, coaching, standards, warning, documentation, and a fair chance to correct. That is not what the record shows. The Wilson Harvey messages were not feedback to me. They were comments about me, private attacks on my work ethic, honesty, intelligence, skills, focus, and character. They were shared with people who controlled my work, my review, my grievance, my reputation, and eventually my job. This is where the numbers matter because they show timing and escalation. 74% of Wilson's private adverse comments about me occurred after he learned of my actual age.
Mr. Zedlar?
Yes.
Please don't use the name of your supervisor, who is not a name in this complaint.
Okay. So this was not random background bad-mouthing spread evenly over time. The bulk of the negative ledger came after the age and career stage issue surfaced. More than half of the comments happened after I filed my grievance and invoked HR protection. But the private commentary did not stop after my complaint. It intensified, and the escalation was not just numerical, it was qualitative. Before the grievance, my manager, his private comments mostly attacked my credibility and skill. Following the grievance, the language of removal took central stage. Risk, extensive oversight, junior framing, blocker, micromanagement, failure to follow through, others noticing, less productivity. In other words, after I involved HR, the private ledger became a sharper, more formal means to justify pushing me out. That matters because after a discrimination grievance, Excella should have separated me from my manager's influence. preserved neutrality, and required direct documented performance management if there were real issues. Instead, without my knowledge, the same private channel kept churning out adverse commentary about me. The next major error is the report's treatment of age. The report says I alleged that my manager learned my age and then I was subjected to hostile work environment. That misstates the point entirely. I was treated badly before he knew my actual age because he thought I was a millennial at the beginning of my career. That bias shaped how he treated me. It explained why my experience did not count, why my recommendations were ignored, why I was treated condescendingly and dismissively, and why senior level conduct was reframed as arrogance or defensiveness. Then he said the quiet part out loud. When I objected to being equated with a designer who had only months of UX experience, my manager said, "You're what, 30 at the beginning of your career?" That was not just an offhand comment about appearance. It unambiguously tied age to career stage. It explained why my protestations fell on deaf ears. My manager simply could not reconcile the experience I was describing with the age he thought I was. He literally knew nothing about my professional background, despite having managed me for close to a year. He reduced me to what he thought he saw. That is why this case about perceived age and perceived career stage. I am almost 60 years old. I already fought for respectability and credibility when I was 30, never imagining that I'd have to endure it all over again at Excella. The report's treatment of the transfer is also faulty. The report says the report says it was not a demotion because pay and title did not change, but I was specifically hired and vetted for that very design role. I waited 9 months for that program to spin up. I was well qualified for it. I have more than 30 years of IT experience, including 20 years in user experience design alone. I even won design awards at other companies. My effective replacement had mere months in the field. Removing me from the role I was hired to perform was not a neutral shuffle. It cost me the job I came to Excella to do. It cost visibility, ownership, credibility, advancement path, and professional standing. It sent a message inside the organization that I'd failed. The heart of this case is retaliation. I did everything I was supposed to do. I went to a mentor for advice. I escalated to management, then HR. I spoke with my manager one last time before filing a grievance. Around that same time, he wrote privately that he, quote, had no goodwill left, end quote, and was not sure he could be a fair supervisor to me. That should have set off alarms. Instead, Excella left me under the same influence structure and assigned lesser work at the absolute bottom of the pecking order. His boss, the recipient of the private ledger, became my supervisor, and the ledger continued. Within weeks, HR closed the investigation. I asked for the investigation details. I was denied. I asked for the records supporting my alleged deficient skills. I was denied. I asked for proof that the federal client had requested my transfer. I was denied. I then filed with the EEOC and later the MHRC. My health deteriorated badly enough that I went on short-term disability for about 3 months. When I returned, there was no effort to discuss the events. I myself had to initiate my own annual review meeting. At that meeting, I objected again and said I believed I was being retaliated against. Within a week, I was fired. The next day was the deadline for my EEOC right to sue window. That timing is not subtle. This is not a collection of unrelated events. It's a pattern right out of the retaliation playbook. The EEOC says retaliation can include firing, making work more difficult, changing assignments, increasing scrutiny, and other actions that would discourage a reasonable person from asserting rights. Excella's conduct fits this pattern to a T. The report misses that chain. It treats each link separately as if the transfer, grievance, review, disability leave, April 17 meeting, termination, police visit, and unemployment fight are all isolated events, but they're not. They are all part of the same tightening chain. The report treats my April 17 statement as threatening conduct. That is absolutely wrong. It was not made in a vacuum either. Here's the context. I was told the worst review of my career was already decided and would not be changed. I was told that in the name of objectivity, my grievance, short-term disability, discrimination, bullying, all of it was scrubbed from the record and would not be included. I raised protected concerns multiple times. My exasperated comment was part of that complaint. The people actually in the room treated it as hyperbole. The meeting continued. Future work was discussed. HR rep her own statement, notes, and report indicate no malicious intent. HR's initial response was measured. The later danger to all employees story hardened only after after the supervisor pushed the issue beyond the HR sphere and into the C-suite. The report's failure to grapple with that full chain matters and is a tremendous oversight. I am not asking the commission to decide every fact today or to resolve disputed facts against me at this stage. Missing records are not neutral. Private bad-mouthing I was not shown is not supervision. A later threat label is not the same thing as what people in the room actually understood.
Mr. Zedler, that is your time.
Sorry, I have one more sentence to go.
Commissioner questions for Mr. Zedler? Commissioner Douglas?
Good afternoon.
Good afternoon.
Did you want to go ahead and spit out your last sentence there?
Yes, if I may.
Well, it's not like a 20-minute sentence. Yeah, go ahead.
I am asking you to look at the entire retaliatory sequence. When it's viewed as a whole, the picture of textbook corporate retaliation snaps into focus. As a result, I respectfully ask the commission to determine reasonable grounds.
Okay. Thank you for that. So I'm looking at the investigator's report. Thank you for your presentation. I'm looking at the investigator's report, and it notes some performance concerns, and then the investigator concludes that, I mean, you've submitted quite a bit of material here, but you don't really refute the concerns. Noting I'm looking at a very interesting looking frog here now. So yeah. Oh, I want to make sure it's still here.
Mr. Zedler, are you still with us?
It's a turtle. It's just like a frog.
All right, how's that? Sorry.
I've been corrected since you've been gone. Apparently that's a turtle and not frog. So anyway, I'm asking you about these performance issues that are identified in the report, and then the investigator's statement that you didn't really refute those. And specifically what I'm seeing here is you lacked production, you're not participating in meetings, and you would miss meetings. You want to discuss those?
Those are exaggerated claims. And all of this was in the context of increased scrutiny, psychological manipulation. The situation I had to, I was assigned to a new position where I had to learn software that I told them I didn't know. And then I was being judged about that. So it was clear to me that I was set up to fail, and my health continued to take a toll as a result, which eventually led to my doctor saying I had to take some time off from work because my hair was falling out and my teeth were cracking from grinding at night. And so the situation was a bit dire. And so I don't deny that the situation affected my work to some degree, but I do contextualize it as part of a campaign to make me either quit out of frustration or mess up enough to be fired.
Okay, thank you for that. And then there's this statement on April 17, 2023, during this meeting, which you referenced, where you said, quote, "Someone would have to walk into an office and shoot somebody in the head in order to get below expectations."
Yes.
Close quote. And my understanding of your position there is that you did say that, but that statement is being taken out of context.
Yes, I did say that, but it was not a threat at all. Even the HR representative who was present said that she agreed that it was not. a threat at all. It was simply hyperbole. Only later was it used as a pretext for my firing. It wasn't even included in my termination letter. I only got a boilerplate conduct violation form letter. So it wasn't even, they couldn't even slap together a coherent reason to terminate me at that time.
Okay, thank you.
Any other commissioner questions for Mr. Zedlar? Commissioner David?
Mr. Zedlar, your claim of retaliation is that there retaliation for you making the complaint about age discrimination?
Yes.
Okay. And you're saying all of this behavior by the, is it a supervisor?
Mm-hmm. Yes, a supervisor and a manager.
A supervisor and a manager is all in your view based on age discrimination because of your appearance younger than you are?
Yes, absolutely. I've had a long career and I've never experienced anything like this. I could not conceptualize why I was being treated like a newbie in the field. And it was a consistent pattern of behavior. No matter how much I said I have experience, I know what I'm talking about. I have ideas. There was inexplicably held against me for some reason until the explanation did come out when my manager made.
Yeah, but if it was based on the age discrimination and the mistaken view that you were younger than you are when it did come out, why didn't it end? If you're correct that was the reason.
Because the real world doesn't work that way. They doubled down rather than admitting their faults. I think.
Okay. Yes, I understand. That's what you're saying. Yeah. Okay. Thank you.
Yes, sir.
Any other commissioner questions for Mr. Zedlar? Seeing none, we will move to Attorney Snyder. Good morning. Good afternoon.
Hi, good afternoon.
Whenever you're ready, go ahead.
Perfect, thank you. Good afternoon again. My name is Kaylin Snyder. I'm here on behalf of the respondent, Excella Consulting. Investigator O'Reilly has spent, a good amount of time reviewing the full record in this case, including the voluminous submissions from Mr. Zedlar, and reached a clear recommendation. There are no reasonable grounds on either the age discrimination claim or the retaliation claim. And today I'm here to ask the commission to affirm that recommendation. Mr. Zedlar was hired as a senior designer in January of 2022 and performed well for that first year. That's undisputed. Starting in 2023, however, his performance began to decline, and that decline is documented contemporaneously in his quarterly reviews. By August of 2023, when Mr. Zedlar raised the subject of a promotion, his supervisor told him directly that he was falling short. Among the issues that were raised were missed meetings, low participation, and insufficient production. The record shows that Mr. Zedlar became defensive and agitated in the face of that constructive criticism, and that he refuted the substance of that feedback. A month later, he was reassigned to a project that his supervisor believed was a better fit for his strengths. He received the same title, the same pay, the same benefits while working on that new project. Mr. Zedlar calls this a demotion and emphasizes the lack of visibility or the lost visibility in that transfer. But the objective record is that he was a senior consultant designer before, and he remained a senior consultant designer after, at the same compensation and with the same benefits. By definition, that's a transfer. That's not a demotion, regardless of how it's been characterized after the fact. During that same conversation, the supervisor made an offhand remark that he assumed that Mr. Zedlar was younger than he actually is. Again, that is not a disputed fact. Mr. Zedlar then filed an internal complaint. HR investigated it independently, and the director, not the accused supervisor, took over as Mr. Zedlar's direct supervisor going forward. Excella responded promptly and effectively. It investigated and removed the accused party from any position of influence. He filed his internal age complaint on September 12th, and the same day the director took over as his direct supervisor. This wasn't weeks later, it wasn't after a delay, it was the same day. So the claim that there was an intensified treatment of Mr. Zedlar after the complaint runs the problem that, you know, he was not even being supervised by this individual anymore. The supervisor who made the age comment had no role whatsoever in the decision to terminate Mr. Zedlar months later. That decision was made by general counsel, HR director, the vice president of people services, none of whom were involved in any age-related remark ever. Just any age discrimination claim cannot rest on a comment from someone who wasn't in the room when the adverse decision was made regarding Mr. Zedlar's employment with the company. It's also worth noting Mr. Zedlar isn't alleging Excella discriminated against him for being older. He's alleging that the supervisor mistakenly believed that he was younger, and that mistaken belief caused an adverse action. As the investigator observed, that theory collapses on its own logic. If the supervisor held a bias favoring older, more experienced workers, learning Mr. Zedlar was in fact older should have improved how he was treated, not worsened it. As it relates to the termination, Mr. Zedlar said, undisputed, that someone would have to shoot a coworker to deserve his review. This is really the heart of the case. On April 17th, 2024, in a formal review with his directors and HR present, upon learning he'd received a below expectations rating, Mr. Zedlar said that someone would have to, quote, walk into an office and shoot somebody in the head to get a below expectations rating. Again, it's undisputed that he said that, and it's undisputed that in his director and HR's own opinion that they were stunned and concerned by that comment. What Mr. Zedlar has incorrectly taken from the investigator's report is that the decision to terminate was based on finding that this was a threatening statement or, you know, a direct threat to coworkers. That's not what the record here shows. What the record shows is that just whether or not it was determined to be a threatening statement, it was inappropriate and in violation of the code of conduct for the company, and therefore on its own a terminable offense. An employer doesn't need to prove intent to kill to have legitimate grounds to end an employment relationship after a workplace shooting reference unprompted in a formal review. The investigator arrived at the correct conclusion. It was objectively reasonable for Excella to treat that comment as grounds for dismissal, full stop. A measured reaction from HR doesn't erase what was said in that room on that recording, which Mr. Zedlar submitted in support of his charge. The decision here didn't arrive in a vacuum of good performance. The investigator found performance concerns behind that review came from multiple sources across the year, not one supervisor with a grudge. A review his own director explained in writing. Inconsistent delivery, missed deadlines, confusion, veering off from the task, missed meetings without notice. But even setting the performance history aside, that comment alone is enough. Standing by itself, it's objectively grounds for dismissal. The investigator found there was enough here for a prima facie showing, but that's just the first step. Excella has articulated a legitimate non-discriminatory reason, and then the burden shifts back to Mr. Zedlar to show that the reason was untrue or that age was the real cause. He spent a good deal of time criticizing Excella's performance management system generally. That's a system that's been effectively used successfully by the company for years. What he does not do anywhere in his submission is offer evidence that Excella's stated reasons, poor performance, the comment in his final review, are untrue. He does not provide evidence of other age-based comments or bias to support that his discharge was based in any part on his age rather than his performance. On the other hand, the record includes evidence that complainant did not meet performance standards and was becoming difficult to supervise. If you read his own disagreement closely, it actually provides support for the investigator's point rather than rebutting it. Page after page catalogs exactly the friction, defensiveness, and conflict with supervision that Excella identified as the performance problem in the first place. At no point does Mr. Zedlar actually dispute any of that happened, and he needs to show the adverse action was based on his protected class status, not something he personally disagrees with. The only evidence he offers of pretext, start to finish, is that single offhanded comment from the supervisor about him appearing younger than his age. Mr. Zedlar's agreement introduces a new framing, this private ledger, the communications ratio, seniority comparisons. None of that changes the facts that decided this case. The performance concerns were documented in formal reviews. He received them directly from multiple sources, and he does not dispute making the shooting comment. Ultimately, this is a case where his performance declined over a year. It was documented from multiple sources, and one supervisor's offhand comment was investigated, addressed, and had no role in the final decision. The employment ended after that employee was told by his director in HR that that he told his supervisor in HR that somebody would have to shoot a coworker to deserve his rating. The investigator got the facts right here and reached the only reasonable conclusion, which is, a finding of no reasonable grounds on both claims. So that's all I've got. Thank you.
Commissioner questions for Attorney Snyder? Commissioner David?
Attorney Snyder, how long is when the director takes over from the supervisor? That's because they wanted to have somebody else because of the tension with the supervisor, right?
Yeah, and because they were investigating the report of the age-based claim.
So how long is the director in that role of supervising him and having direct review
So
of
that
his
report, the
employment?
complaint was made September 12th, and that director continued to supervise Mr. Zedlar until the date of his termination, which was, I believe, in April of the following year. So maybe 7-ish months.
Okay, so it's a good long time that he's experiencing what the company alleges is deteriorating performance.
That's right.
Yeah, okay, thank you.
Any further questions for Attorney Snyder? Okay, we've heard from the parties. Next, we'll hear from Jane.
Good afternoon, commissioners. I'm Jane O'Reilly. I was the investigator on this case. I'm not going to bring the file up, but I did find the commissioners are interested in the context, the meeting was recorded, the review meeting where the statement was made was recorded, and there's a transcript in the file of it, so I can give the statements before and after if it's meaningful to anybody. But ultimately, I just wanted to refocus on the fact that even if the reasoning for the termination was good or bad, there was no evidence that it was connected to a retaliatory motive or that it was connected to age-related bias. As was mentioned, it was sort of one comment that was taken as extremely offensive by the complainant in the meeting, but the investigation showed there was nothing about it that indicated age-related discrimination. My investigation into that, both sides of the story in terms of what that meeting was, came to the same conclusion. And then after he reported it, they made efforts to try and get him away from a supervisor who he clearly had conflict with, and to continue to, work with him. He was not under any other type of disciplinary action because of that. And then he had this review. I will say that even though so in September, director became the new supervisor, but then complainant was out on leave for like 3-ish, or early in 2024, he was out on leave for several months. So it was sort of September through the end of the year. And then it was his annual review that was prepared at the end of the year that was delayed because he went out on leave. And then they did that in April. So that's sort of the period of time that she continued to see the declining performance issues. That's really all I have, but I'm happy to answer any questions.
Commissioner questions for the investigator? Okay,
thank you.
We have heard from parties and the investigator. At this time, we are looking for a motion. There are 2 proposed findings.
Commissioner Douglas.
Yeah, I'll move that we take these findings together and that we adopt the recommended findings of the investigator. There are no reasonable grounds to believe Excella Consulting discriminated against complainant on the basis of age. That there are no reasonable grounds to believe that Excella retaliated against complainant for engaging in WPA and or MHRA protected activity. The complaint should be dismissed.
Second.
Moved and seconded. Any discussion?
I mean, I think the basic thing to be said here is that I understand the complainant had a hard time here. But you know, regardless of what we think about the statement in that last meeting about shooting somebody in the head, etc., I just don't see any evidence of any discrimination here. So I don't think that really, you know, so yeah.
Commissioner David?
I completely agree that even without the statement, which you could say, well, that's hyperbole, that's not that a threat to kill anybody, but there's no tie to age discrimination on this gentleman's appearance. I mean, that's an offhand comment as far as I can tell, and is not supported by continued reference to that.
Further discussion? Seeing none, the motion is to find no reasonable grounds. If you were in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
So the findings are no reasonable grounds. The commission will send a letter to the parties and the council confirming the results of the hearing. Okay.
And it was a little,
Ed,
yeah,
just like a 3-minute break.
okay. Go for it.
Thank you. I'll exit.
All right, Ed, we're ready whenever you are, although it looks like Julie is. Oh, there's still
Out of nowhere.
just on the screen.
Moving fast with that boot.
There she is. So the last two cases, I was a little confused as to how they're different, but somebody will disabuse me, I'm sure. I thought that might be able to be taken together. H 262 A, B, and C Bridge Support Services versus Country Estates et al.
Yes.
And the recommendation is for no reasonable grounds on all three allegations. We'll hear from complainant.
I numbered them incorrectly in the drive, if that's what you're looking at. He's going in the order on the agenda, which is what I should have done.
So very interesting. We just have everybody argue. At the same time.
I do feel for Attorney Haley, they're like mostly the same arguments, but not quite. So I think it makes sense to take them separately. I assume that you're, yeah, okay. Okay, so we are looking for, I believe, Attorney Benchik. I don't see it.
It's a complainant.
Yes, do you want me to check my email? Sure. Turn off the
I don't have anything from
the whole room doesn't need to see my email.
I'm not following. Is nobody here for a complainant on either case?
Barbara shout just all of a sudden. Yeah, exactly like this. The last emails I have from him are submitting the disagreement.
well, I've not received any.
Yeah.
Interesting. You turn the screen back on, Jane?
Yep. I'm just being very sure my.
Okay, so we have no communication from the complainant or their attorney. I assume there's nobody else here for complainant bridge support services. I see Mr. Bose, but I don't see anybody from, let me just, okay. Ms. Delano, who are you here for?
She's with Paul.
She's with Paul Bose, okay, great. Nice to see you, Andres. Okay, well, in that case, we would generally have a motion to adopt the findings in the investigator's report.
So moved. On both counts, no reasonable grounds.
Second,
Moved and seconded. Any discussion? Okay, seeing none, the motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
yes.
Commissioner Douglas?
Yes.
Okay. All right, so the findings on that one are no reasonable grounds. We will send a letter to the parties confirming the results of the hearing. And we'll move on to the next one.
So H and PA 26, 45 A, B, and C, Paul Vos versus Country Club Estates et al. Recommendation is for no reasonable grounds on the two counts in that case, and therefore we would hear from complainant. And is it the case that no one, oh, someone is here for that? Okay.
Attorney, can you have 10 minutes?
I'll reserve whatever remains.
Okay, whenever you're ready, go ahead.
Thank you, commissioners, for having us here today. I represent the complainants Paul Vos and Paul Vos LLC. Vos is the owner and landlord of the two houses at issue today, in which a total of 4 individuals with disabilities lived. I'm here to respectfully ask the commission to set aside the investigator's report and find that there are reasonable grounds, that is, that there is at least an even 50-50 chance that respondents 1, unlawfully refused Vos's reasonable accommodation requests, 2, intentionally discriminated, and 3, unlawfully retaliated against Vos. Before getting into each claim, I want to make our position clear. The respondents' actions forced individuals with disabilities to vacate the houses they resided in. That is both wrong and what the FHA and MHRA were created to prevent and address. Additionally, we fundamentally disagree with the report's narrowing of the law to exclude the claims of a landlord that were brought on behalf of its residents. We urge this commission to reject the report's incorrect analysis and conclusions, because not doing so would be an unprecedented departure from and directly contrary to the FHA's and MHRA's purpose and legal authority. For example, the law does not state that a reasonable accommodation claim can only be brought by individuals with disabilities. And the law does not state that there can be no discrimination when an HOA is enforcing a neutral covenant that was breached. If the commission accepted that the idea that only a person with disabilities can bring certain claims, and that an HOA can escape liability if they are merely enforcing a neutral covenant that was breached, then the purpose of the FHA and the MHRA and the legal authority would be meaningless in Maine. I will now address each claim, starting with the reasonable accommodation claim, then going to the intentional discrimination claim and the retaliation claim. So first, reasonable accommodation. Here, VOS made reasonable and necessary requests for waivers of the no business covenants and the fines. Without these requests, the residents with intellectual and physical disabilities could not live in the houses, something proven by the fact that those houses now stand empty. Respondents denied VOS's requests. The report through footnote 1 concluded that this claim must fail because according to it, only individuals with disabilities have standing to bring such a claim. That is wildly inconsistent with the fundamental policy of the law and the legal authority presented to the investigator. Instead, the law is clear that VOS is an aggrieved person, and therefore VOS has standing to bring this reasonable accommodation claim. An aggrieved person is any person who claims to have been injured by unlawful housing discrimination. As the DC Court of Appeal stated, quote, "It is well settled that landlords have standing under the Fair Housing Act to sue those who would prevent them from renting their property to tenants with disabilities," end quote. VOS, the owner of the now empty houses, unquestionably has standing to bring this claim. Turning to the merit of the claim, respondents argue that they refused the request because they were, quote, "unreasonable under any circumstances," end quote, and that they would fundamentally alter the nature of the HOA. This flies in the face of the legal authority that has held the opposite to be true. That is, that it is eminently reasonable for an HOA to waive enforcement of its no business covenant when the business the HOA is trying to exclude is the provision of care and services to individuals with disabilities. VOS has proven that respondents unlawfully refuse its reasonable accommodation claim. Second, intentional discrimination. The report ignored the relevant direct evidence that showed respondents' discriminatory animus and improperly narrowed its focus only to whether complainants were subject to different terms and conditions. Contrary to the report, the Federal District of Maine recently stated that an FHA intentional discrimination claim requires the complainant to show two things: disadvantageous treatment and a disability-based discriminatory purpose. Disadvantageous treatment includes to otherwise make unavailable or deny a dwelling to any buyer or renter because of a disability. Otherwise make unavailable or deny includes, quote, "the act of enforcing a neutral restricted covenant for the purpose of denying equal housing opportunities to disabled individuals," end quote. Here, the houses were made unavailable and denied to the residents with disabilities because of respondents' enforcement of its no business covenant. As for the discriminatory purpose, the report ignored direct evidence in the record of respondents' discriminatory animus. In January 2025, before respondents sent VOS their cease and desist letter, Tim Swenson stated that he and, quote, "his partners were upset because they thought it would be difficult selling the remaining homes with a group home there," end quote. Clearly, respondents were motivated by the fear that the group home could have an economic impact on the houses that still needed to be sold. This is an impermissible and discriminatory motivation. In fact, federal courts have held that concerns that a group home could affect property values constitutes evidence of discriminatory intent. However, as if that was not enough, the record has additional direct evidence of respondents' animus. Before the January cease and desist letter, Swenson grilled and accused the home builder of having purpose-built the houses for use as group homes and stated that he and his partners were, quote, "pissed that the houses were being used as group homes." Then, on November 7th, 2025, months into respondents' enforcement effort, the current HOA president summarized the HOA's position. Quote, "Say he doesn't sell the houses. He comes back and tries to do it with another company. And he does go through the normal procedure, submits the leases to us. We deny him. He's going to come back and say it's discrimination. And now there's a history of discrimination here. So that's why we're afraid to settle on, I won't do it again. It has to be, I broke the rules. And he won't admit to that at all. End quote. Despite what respondents claim, the direct evidence shows discriminatory animus from the decision makers. Therefore, VOS has shown respondents intentionally discriminated. Third, I'll briefly touch on the retaliation claim. The report concludes that there's no causal connection between any MHRA protected activity and respondents' adverse action. Such a conclusion ignores both the timing of events and the intention respondents' words and actions reveal. Respondents began fining VOS after he made numerous requests for reasonable accommodations, and even though 12 Magnolia was already vacated. And as stated above, the report failed to acknowledge the discriminatory animus respondent had well before it decided to sue VOS. The conclusion is also contrary to the law. According to the report, asking for a reasonable accommodation does not rise to the level of an MHRA protected activity. The FHA makes it unlawful to, quote, coerce, intimidate, threaten, or interfere with any person on account of having exercised or enjoyed, or on account of having aided or encouraged any other person in the exercise or enjoyment of any right granted or protected by the act, end quote. At a minimum, VOS has had its ability to allow individuals with disabilities to live in its houses interfered with by respondents. I want to conclude with what the federal circuit courts that have directly addressed this issue have held. Quote, the FHA was designed to end the unnecessary exclusion of persons with handicaps from the American mainstream. And the FHA defines equal opportunity to give handicapped individuals the right to choose to live in single-family neighborhoods. For that right serves to end the exclusion of handicapped individuals from the American mainstream. We ask this commission to set aside the investigator's report and find that the minimal threshold of an even 50-50 chance has been met for each of VOS's claim in order to end the unnecessary exclusion of persons with disabilities from Maine's mainstream.
Commissioner questions for Attorney Kenny?
Just ask a basic question. What were the claims alleged in your charge of discrimination?
The claims alleged in the charge. Yeah. Let me pull that up. So one point of clarification here is that VOS's counsel was hired after the claim was submitted. So that's why I'm going back to the specific claim to tell you that.
Yep.
So the cause of discrimination is physical or mental disability. Would you like me to go through the particulars?
No, I'm just looking for the basics. I mean, you've got.
So, okay, the basics are there is a reasonable accommodation claim, that there was intentional discrimination, and that there was retaliation.
I want to make sure I don't confuse this with the other case.
Mm-hmm.
If it's helpful, I can state the other case.
All right, so I see that you've got some references to the Fair Housing Act.
Yep.
Is that raised in the charge?
In the charge, it was additionally raised in the reply that we at that point were counsel for complainant. It was raised in the IRC itself and then raised in subsequent writings.
All right, I'm going to reserve the rest of my questions until next time I see you.
Commissioner David?
Are you not necessarily arguing that the covenant is void and discriminatory and can't be enforced? The covenant not to have a business in those houses?
No, what we're saying is that in this instance, there was an action taken. That action led to the vacation or 2 houses being vacated by individuals with disabilities.
And the people, they were a business of providing services to people with disabilities, right?
There was the bridge support services is an organization. Whether you would like to call it a business or not is not my determination. But they are an organization that provides services to individuals with disabilities. And so that through Bridge Support Services, 2 individuals at each house, so a total of 4 individuals with disabilities, were allowed to live in the house with 24-hour care, which is what they needed in order to be able to live independently.
But is that not a different situation than a person with a disability buying the house?
In terms of the actual facts of what happened, I would say yes, but I'm not sure I understand the question, Commissioner. If it's worth,
I guess I want to ask counsel, is the covenant in regards to a business legal? In other words, if the covenant was not to allow Black people, or the covenant was not to allow females that are unmarried, that would be unenforceable and illegal, would it not, Barbara?
so
He meant.
Although feel free, I mean, no. So yes, that would be illegal. It would also be illegal if the covenant said no individuals with disabilities. That's not what it says. It says no businesses.
Right. And it seems as though that's a distinction. And you are not saying that distinction is of any importance.
Would you
I
like
would
to-
For Barbara or for Attorney Kenny? Or just a
No, I'm asking counsel. I'm sorry, I'm not seeing your name. I'm asking counsel.
For the party or because you
No, for the party, I'm asking.
Okay,
I'm
Attorney
asking.
You could just call me Barbara.
I do repeatedly.
I know.
So I'll try to respond to what I understand the question being. There are different types of discrimination claims. There are what we have in this case, which is intentional discrimination, also known as disparate treatment. And then there's another type of discrimination claim called disparate impact. And what I hear your question being more towards a disparate impact claim, which is not at issue in this matter. Disparate impact claims deal with, there is a neutral facing law or regulation, or in this case, an HOA covenant. And just the only way that can be applied, it will have a discriminatory impact towards a protected group. Here, we're not talking about that. We're talking about, in this specific action, we have direct words from the decision maker, Mr. Swenson, who, as I said, is the president of the HOA, is the partner of the LLC developing the HOA, stating that he and his partners at the LLC and in the board are upset and worried that the presence of this group home will affect their ability to sell the rest of the houses. Also that he is, quote, pissed that this group home exists here. And all of that happens, and this timeline is important, all of this happens before the respondents sent their first cease and desist letter on, I think it's January 25th or 21st, 2025. So in the lead up to the enforcement beginning, we have direct words, direct evidence of the motivation for why that is happening.
Right, and they claim that they're enforcing a covenant against the business, and they have facts to that they allege that support the fact that it's not just an individual with disability living there, that it's a business of providing services, with providers coming in, with traffic, with parking, with, all of those things. Doesn't that make it a different case than a denial?
I would disagree with the characterization that there is facts that support any of those conclusions.
Alleged facts, yeah.
What we have is, if you look through the record, there's an unnamed partner and board member who gets a email from another HOA member, and I've read through these things. The HOA member talks about meeting with a BSS member. And the BSS member says, we are moving in. We would like to be good neighbors. Please let us know if there's anything you would like us to do. From that, there is one comment. In that comment, they say, yeah, we're also moving in some computers. That then gets told to the unnamed partner and board member, who takes that individual snippet and says, they are running a business out of these houses. They are conducting business in these houses. And in addition, these traffic concerns mean that there's a business happening here. But that is not the facts on the ground. There were no other individuals other than the 4 individuals with disabilities living in those houses. They did have direct care provided by BSS, and that direct care needed to be 24 hours a day. And when we talk about the traffic concerns, we're talking about the coming and going of that direct care and additional care for these individuals. So even in their cease and desist letter from January 21st, they acknowledge that these are individuals with disabilities and that BSS is providing these support services. Later on, they talk about how it's these pharmacies coming and going, dropping off, that's adding to the traffic. It's the nurses that are coming and going, that's adding to the traffic. It's the fact that there has to be 24-hour care, and there's some care during the day and some care during the night. And when those two switch, there's more traffic there. And so while we understand that to be a concern, fundamentally that misses the point that what is being concerned about is the care of individuals with disabilities in order for those individuals to live independently in a home of their choosing.
I understand the argument. Thank you.
Any other commissioner questions for complainants council? Seeing none, you will have a minute and 20 seconds. Only 2. Good afternoon. I was going to have 3. Do you want to reserve any of your time?
No, I'll just reserve whatever I have left. So I represent the respondents Country Club Estates Homeowners Association and Timothy Swenson, and attorney Stephen Bell represents Country Clubs Estates LLC. So
are you presenting for all of the respondents, or would you like to split your time?
How do you want to?
I expect that I'm just going to join with whatever Attorney Haley has to say, and if my position on that changes, I'll let you know.
Okay, and certainly if you have specific questions to the LLC.
I think if there's something you want to add to it, we can add a bit of additional time on.
Thank you.
All right. What I want to begin with is that in the opening statements, we heard 2 very key concessions. 1, neutral covenant, and 2, that was breached. And that is exactly what this case is about, and it is all that this case is about. So the Country Club Estates are a subdivision that are bound by a declaration of restrictive covenants that run with the homeowners and also with their tenants. And among the provisions of the covenants restrict the use of properties to single-family residences, prohibit use of properties as businesses, any kind of business, doesn't matter the nature of the business, direct that cars must be parked in parking areas on a lot, and also require that if you are going to lease your property, that the lease is provided to the association for pre-approval prior to the lease being executed. None of those things were complied with here. I don't think that there's any dispute here that the tenant is a business. The tenant is not individuals with disabilities. The tenant is an organization, Bridge Support Services, that Vose LLC rented the properties to. We have never learned the legal relationship between that business entity and the individuals with disabilities who are purportedly residing in the properties. And so when we talk about landlords taking action so that their tenants with disabilities are not denied housing, that is not the case here either, because the tenant is a business. The tenant is not an individual with a disability. So there's no dispute that the company operated businesses from the property. There is no dispute that it was not just Mr. Swenson who observed increase in traffic. It was other members of the LLC. It was other residents of the community that complained about increased traffic, complained about parking We submitted videos, we submitted photos as well, with cars hanging out into the street, blocking sidewalks, parked on sidewalks, parked on curbs. One of the members of the LLC submitted an affidavit that she saw 50 cars coming and going in a short period of time. We've submitted a timeline of hundreds of cars moving within a short period of time. The road is a private road, so if cars are parked on both sides of the road, emergency vehicles cannot get through. These were the complaints. These was the issue, not the nature of the business at any point. And the company is not requesting accommodation on behalf of a tenant with a disability. The accommodation that they're purportedly requesting is that you don't enforce this business covenant. But Mr. Vos is a real estate agent. Mr. Vos knew what the covenant said prior to him purchasing the homes there. He knew what the covenant said prior to leasing them to Bridge Support Services, and it's our understanding that he never told Bridge Support Services that they were restricted, no business covenants, and that's between the two of them. But that's the reason why the businesses are not allowed to operate in the covenant. It has nothing to do with the nature of the business. If we waive the no business covenant for that, where does it end? It could be somebody, it could be a law practice. It could be, your what?
Joking.
Yeah, you could move in. No, it could be, like, where do you go with how far you're extending the no business when people buy those homes because they're expecting a residential only neighborhood? Again, nothing to do with the nature of the business. And it's also important to know that these cease and desist communications began in January of 2025. There is ongoing litigation running in parallel to this with the business court, where the business court has said that there's a business operating in violation of the covenants and that there's a likelihood of success on the merits as to the breach of covenants claim. The business court also held that any sort of statute about group homes being under a single family use does not apply to restricted covenants. And if you impose that, then you're changing the nature of restricted covenants from Kittery to Fort Kent, is what Judge Duddy said in that case. And so, the accommodation to just waive the no business provision is not a reasonable accommodation. And there's also been an admission that what the complainant is seeking is a reduction of the fines associated with complainant's breach of covenants. So you're asking for a reduction of fines from the covenant that you admittedly breached, which is also not an appropriate, reasonable accommodation, because then again, any homeowner who breaches the covenants and then asks for a reduction of the fines because they breached the covenants, that's not the purpose or the letter of the covenants or the supporting law. So I will reserve my remaining time. And of course, happy to answer any questions anyone may have.
Commissioner, questions for Attorney Haley?
Yeah, so I was gonna ask you to lead us out of the wilderness.
Yes.
I feel like I can at least see the edge of the woods now. So all of these, the complainants made a tremendous effort to get us to consider an alternate approach to all of this. And I guess I'm wondering, since you referenced the court action, these arguments raised in front of Judge Duddy.
So Mr. Vos is not, and Vos LLC has not raised counterclaims in that litigation. There are other counterclaims that mirror the claims that were part of Investigator O'Reilly's case that we have not heard, that we did not hear about today. But Mr. Vos is not party to those claims.
And I did not know that. Okay, so from your perspective, this is it's just a business covenant, right? All of these statements that the complainants raised in their submission that are supposedly evidence of discriminatory animus, we're gonna have a hard time selling these homes, et cetera, et cetera. They were built as group homes and all this stuff. So, as far as you're concerned, that's of no moment whatsoever.
It is.
Right, it's just a business covenant, they're running a business, it runs afoul, it's the same as any other business.
Correct.
That's your position.
Correct.
Other commissioner questions for Attorney Haley?
I just want to make sure that I'm correct. Vose bought the houses, those two houses, the covenants in his deed when he bought them for
Yes.
no business, and then he's leasing them to Bridge Services LLC.
Correct.
Correct.
And never provided a copy of the lease for approval prior to leasing the businesses.
Okay. And you think, well, the complainant mentioned that there were 4 individuals residing there, 4 different individuals with disabilities, but that's a minor violation of the single family part of the covenant, right?
It's about the operation of the business.
Yeah, right.
This is about. And even during the issues of resolutions conference, the question was posed, well, if it was a lease with individuals with disabilities, would you feel differently? And the answer is yes. It's not about anyone who is in the houses having a disability. It is about renting the houses to a business without having the lease approved in advance.
Thank you.
Any further commissioner questions for Attorney Haley? Seeing none, you'll have about 12 minutes. Okay.
I'll again join in Ms. Haley's presentation to the commission.
Okay. Nothing further to add. Penny? 1 minute and 20 seconds left.
So let's go back to the facts of this case. There is a business supposedly here, Bridge Support Services, but why do they exist? They exist to allow individuals with disabilities to live independently in the homes of their choosing. I'm not the representative for Bridge Support Services, so I cannot tell you the legal relationship, but through my communications with them, what I understand is that these individuals have severe disabilities and for that reason are unable to enter leases on their own. If we accept the position that respondents want you to accept and what the report accepts, it means that you're limiting the ability of the law to address issues where there is a landlord in between the individual and there's an organization and there's the individuals. That's not what the case law says. We've cited multiple cases, whether it's Gibson Home, whether it's Waia, that show that when there is a landlord, there is an organization, and then there are tenants. That is sufficient for standing because all you need is an aggrieved person. An aggrieved person is anybody who has been affected by unlawful housing discrimination. Additionally, for the reasonable accommodation claim, it is a simple one. Did the respondents know that there were individuals with disabilities there? Yes. Was a reasonable accommodation made? Was the reasonable accommodation necessary? Both of those are yes, because as we see, without that accommodation, those individuals cannot live there. And was it denied?
Commissioner questions for Attorney Penny?
Yes. So some of these statements that you've identified that allegedly show discriminatory animus, couldn't those also just be attributed to sort of non-discriminatory concerns about having a business in the neighborhood? Like, for example, this comment about, we're gonna have a hard time selling these houses, right? Because, I'm just extrapolating here, because there's all this increased traffic and there's cars parked everywhere and it's not terribly residential anymore. Somebody comes, looks at a house and sees that there's clearly a business going on. Is that discriminatory? You know what I mean? Like,
I understand the question.
Yeah.
But the issue is that that's not what the quotes say. I'll read you the first quote. Find it. Tim Swenson said, his partners were upset because they thought it would be more difficult selling the remaining homes with a group home there. Later.
Let's just stop there,
Yep.
right? So be more difficult selling the remaining homes with a group home there, right? Wouldn't that be true of any business, right? I mean, say somebody puts a pizza parlor in next to your place, right? I mean, isn't it, I personally don't want to live next to a pizza parlor. Doesn't it make it more difficult to sell the house? If it's like a nice residential neighborhood and then there's like a pizza parlor that's plopped right down in the middle of it?
So when you're talking about businesses generally, if the quote in this instance had been, I'm worried that a business is entering these houses and will make it more difficult to sell the other houses, I would maybe agree with your question. But here, there's a specific focus on the nature of the houses, which are that they're group homes, which is a group home so that individuals with disabilities can live there. And as I stated in my statement, federal case law states explicitly that when concerns of the economic impact of a group home are in the motivation or the intent behind an action, that is discriminatory intent.
Okay. Are there other statements that you want to highlight for me?
There are the statements, I mean, there are statements I've highlighted in my own statement. I think it's important to highlight that the November 7th, 2025 statement from the current president was made in the midst of the fines being assessed. So one thing that the report has wrong is that the timeline in the report is that in June, there's a consent order, fines are placed in October, they're assessed in November, and then we kind of go forward from there. That's incorrect. The fines were first set to establish in October of 2025. We're talking about 6 months or more after the commencement of the enforcement. The fines began to be assessed on November 15th of 2025. So only 1 week before the fines are assessed do we get the November 7th comment from the current president, in which the current president says, if they went through the normal procedure, we deny him, and now we have a history of discrimination here. This is also important for the cause and effect for the retaliation claim, because part of the retaliation claim is that as a result of asking for reasonable accommodations, of continuing to defend the rights that are there, the fines then get assessed as an additional pressure point in order to force these individuals to vacate the homes. And here, that's what happens. Even before when we get to October, September, 12 Magnolia is already, there's 12 Magnolia and 13 Magnolia. 12 Magnolia is already vacant in September of 2025. When the fines are assessed in October 2025, 12 Magnolia is still vacant. When the fines begin to be imposed on November 15th of 2025, 12 Magnolia is still vacant, even to the consent order that says all people must be removed from the houses by February 15th of 2026, and nobody can live in those houses after that date until the end of the litigation. So to claim that this is just enforcement of a covenant misses the fact that there was nobody there in the first place for one of those houses, and misses the fact that Mr. Vos had continuously, through emails, through other methods, defended his rights, asked for reasonable accommodations, and those accommodations not only were not addressed, their response was to increase the pressure, to fine him, in order to build up thousands and thousands of dollars of fine, and then get to a consent order in which he has to agree, after accumulating over $20,000 worth of fines, that nobody can live there.
Commissioner David?
You're muted, Ed.
Chasing the mouse across two screens. I'm sorry. You mentioned the case law, and I'm sitting here thinking of sure, that's a case where a house is sold and there's no zoning prohibition generally. It's not a development. There's no covenants running with the land for the surrounding neighborhoods. So it's discriminatory to say you can't have a group home. Do you have any case law that is on all fours with this? And that is that you have covenants that appear to be legal and enforceable of no business. But
Yeah,
okay.
that's a great question. This is in the response to the report. It's in the reply, but Group Home on Gibson Island LLC for Gibson Island Corp. That's a Fourth Circuit case from 2025. That is an individual against an HOA. Welsh v. McNeil, that's comes from the District of Columbia Court of Appeals. That's a 2017 case. Again, we have a landlord owner who, in this case, leased the property to an operator, so to a third party, in order for that operator to then use that house as a house for recovering, I think in that case, recovering alcoholics. That was individuals, the landlords, the owners against the HOA. You also have Harmony House Westlake LLC versus Parkstone Proper Owners Association that comes out of the Fifth Circuit in 2021. And then you have, I'm going to butcher this, it's Sombandis, TSOMBANIDIS versus West Haven Fire Department. In that one, you have a slightly different scenario, but the claims were brought by the owner who was then leased it to an operator, leased it to a third party so that operator could house individuals with disabilities.
And the housing, all the neighborhood was a development with covenants against running a business?
In all of those, yes. And in fact, the FHA, when it was amended,
well, I certainly, yeah, I mean, I certainly haven't read the cases. Have you, Barbara? I mean,
All of the case law, is that what you're talking about, Ed?
Excuse me?
Are you talking about all of the case law?
Well, yeah, I mean, I had, yes.
Okay, sorry, I wasn't sure if you meant the case files.
No, I meant the cases. Do you find any cases that are but I guess the question, Barbara, is did you find any cases that are controlling here?
To be fair, I didn't look very hard, but no, I didn't. And certainly federal cases from outside of our circuit are even less persuasive to me than the First Circuit. They're not binding on us. I have not read the cases. I don't know what they say.
Okay, thank you.
Can I make a comment on that?
I see no way of stopping you.
I agree with, what can I say, Barbara?
Feel free, name.
Commission counsel.
There is very limited case law in the state of Maine, and in fact, in the First Circuit itself has said back in 2002 that there is no case law in this, and we're referencing further the other circuits and some of these cases that we are referencing, because there is no case on point where you have an individual who is the landlord owner with an operator with then individuals with disabilities in this circuit or in this state.
Okay, thank you.
Any other commissioner questions for Attorney Campbell? Thank you very much.
Don't really have too much to add. I'm happy to answer any additional questions that you might have.
So many questions.
So many.
So I'm looking at the blurb here from complainant submission about this Gibson case. Homeowner ceased to operate assisted living facility in private gated community covered by private covenants. Receiving a cease and desist. This is on page 9 and 10 of their submission. Sued the HOA for discrimination on the basis of disability, failure to make reasonable accommodation, retaliation. And the Fourth Circuit, which is not binding here, but says, you know, a reasonable jury could find in favor of the plaintiff that the HOA violated the FHA when it refused to make a reasonable accommodation of its business purpose covenant. So anything you want to tell me? It's fourth circuit, it's not first
Yeah.
circuit, but you know.
Well, I think it's obviously fact dependent. So I don't know all the underlying facts of that case. Like for instance, the Welsh case that was cited in the short site, it's represented as claims brought by a landlord who leased property to an operator of a recovery house, but that's not an accurate summary of that case. I did not go through each and every case, but for like the Welsh case, for example, the reason that it was a violation of the covenants was because the lease was in the name of an unincorporated association instead of the 7 women who were residing there. And so an accommodation was granted with that because it was, rather than provide the names of once that lease was explained to the HOA said it was okay for it to be in the name of the unincorporated association, rather than the 7 individual women.
Right.
So they're all very fact specific. And I don't know that this is the appropriate forum to make new law in Maine in the First Circuit, but there's no, there's no dispute. This is a business. They were operating a business. There's an admitted breach of covenant. There was a request for a waiver of the covenant only after a cease and desist was issued. There was requests for reasonable accommodations only after the litigation was commenced. And at that point, the parties are in full litigation, and now you're asking, well, don't enforce your covenants, don't assess any fines, change the nature of your neighborhood. Those aren't reasonable accommodations, especially when we're in the full throes of litigation.
I'm just going to think out loud here, so that you said fact dependent. I agree with that, and then so that the facts in your favor. From my perspective, it seems to me that a lot of these things that are being asserted fall squarely within the concerns that you would have when you have a no business covenant, right? I mean, I don't want a pizza parlor sitting next to my house, right? I don't want 50 cars in my neighborhood parked along the street and all this sort of thing. And the facts cutting the other way are that these people are clearly disabled, right? And they're living there. And they need an exception from this policy in order to continue living there. I'm just thinking out loud. And I see what you're saying, but it's the matter of the lease, that the lease was never brought for approval by the association before leasing to a business. So there's more breaches of.
Yes. Yeah, and so it's, there was never a discussion about this. It was after, it's how dare you make these people move? You're so cruel and callous. You move them into the homes that you knew had a restricted no business covenant without following the procedures of the covenants to provide a copy of the lease for approval. So it's really like none of this would have happened if you A, followed the covenants, and then B, submitted the lease and made a pitch at that time before all the increased traffic and the mistrust and all of that associated with it.
Yeah, I'm not sure how I feel about all the timing issues you're raising, but I hear what you're saying. Yeah.
Any other questions for Attorney Haley? Okay, seeing none, thank you. I can actually catch your name.
Stephen Bell, I have nothing to add.
Okay.
Thank you.
Thank you. And next we'll hear from Angela Morse, who was assigned to this case.
Hello, my name's Angela Morse. I'm the investigator that was assigned to this case. And based on my investigation, I recommend a finding that there are no reasonable grounds to believe that the respondents discriminated against the complainants based on disability or engaged in retaliation in violation of the MHRA. I'm willing to answer any questions.
Any questions for the investigator?
Yeah, so good afternoon, Angela. So the discussion about this group home between the respondents, right? Mm-hmm. I mean, there are certainly a number of statements in the documents we have before us about why they objected to this home, and I'm just curious as to what your findings were, what your thoughts are in terms of. And I think I know what you're going to say, but I have to ask whether this was, people that really didn't want a group home there, people with disabilities in the neighborhood, et cetera, or were the comments and the concerns more aligned with sort of the business covenant issue, right? We don't want businesses in the neighborhood. We don't want the increased traffic and all this sort of thing.
Yes, based on my investigation, there were a pile of documents submitted in this case. So there was a lot of documentation, and from having the issues and resolution conference and getting the testimony from the individuals who were present at that conference, I can say that it was abundantly clear to me that the problem was the breach of the covenants against having businesses at the premises, not illegal discrimination based on disability.
All right, that's helpful. Thank you.
Any further questions for the investigator? Seeing none, thank you, Angela. Heard from the parties and the investigator. We're looking for a motion. There are two proposed findings.
I'd like a motion that we take them together and that we find that there are no reasonable grounds to believe that respondents discriminated against the complainant on the basis of disability, nor retaliated, and the complaint should be dismissed.
Second.
Moved and seconded. Any discussion?
Well, I'm torn and I'm disappointed to have to make that motion. I mean, what we're dealing with is a business that's providing services to disabled people, and I hope they're able to find a place that they can rent. But I can't. If the covenant is not illegal, then this is clearly a violation of the no business covenant. It's clearly a business, and to try to just slip by that and just say, well, these poor people are disabled and we're trying to help them, and therefore that can be ignored, it doesn't seem to be legally correct. So I feel constrained to support the finding. It's not discriminatory animus. It's an unfortunate situation for those individuals that they moved in.
Yeah, I would just add to that, this was one of the more interesting cases that I think I've had in my tenure as a Maine Human Rights Commissioner, and I appreciate what I'm just going to characterize as the tremendous effort by complainants to overturn the preliminary recommendations of the investigator. I just, and I frankly, I wish that I would have liked to have heard this case and the other case maybe on a day with like 4 cases, and I could hear it at 10 o'clock instead of at like 2 o'clock. You know what I mean? Because I feel like we're all sort of like, wow, this is a lot. I mean, I read this case last night and I was like, wow, like there's just a lot here, and I'm still not 1,000% confident in my decision, but I do feel that, looking at what's been alleged, I do feel this is more on the side of the concerns raised were not necessarily specific to a group home, but more specific to, I live here, I want to sell my house at some point, I don't want a pizza parlor next to me.
Any further discussion? Seeing none, the motion is to find no reasonable grounds on both counts. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
So the findings are no reasonable grounds. Commissioner will send a letter to the parties and the council confirming the results of the hearing. Thank you for hanging in for the last almost 6.
I have a motion for executive session.
All right.
Pursuant to MRSA 4056E, I move to go into an executive session to consult with our attorney regarding pending and contemplated litigation and the rights and duties of the commission.
Somebody please
Second.
that. Thank you.
This one isn't hard.
Any
I
all in favor?
don't care if that fails. That's.
I do. Julie, is that a yes from you? Okay. All right, we're gonna take a little break while we work out the technical stuff. Julie and Ed, you will both get an invitation to join a breakout room, so keep an eye out for that. Jane, I'm gonna mention the invite from Mike. Okay.
And we always have that issue about the microphone and getting that close to you three guys that are still there.
Thank you.
Yeah.
Basically, I'm just looking for everybody to disappear.
Attorney, are we now?
You Okay. You pin the, can you pin the, there?
I was looking at the wrong thing. It's fine.
I think
It's up here. It's in the little screen.
yeah, but yeah. I think it affects how it shows up on YouTube. Okay, so we need a motion not to litigate. You all hear me okay? Yeah, okay. No motion not to litigate E24 -0085 England versus the Down East AIDS Network, and to approve settlement in what was H24-0193-A McAllister versus Sapiel. Yes, I need a motion for those two things.
So moved.
Thank you. Ed and Julie, can you unmute yourselves? Great. Somebody want to second that motion?
Yeah, second.
Thank you. All right, if you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Thank you all very much.